Okay, hi everybody. As you can see, we being fancy and festive. How's the sound? Can somebody let me know? Just make sure it sounds okay and it's not too loud. I don't know what... Okay, sound is good. Yay! I'm playing with my new toy. Hello Jim, welcome in. Hello Hawkeye. Hello Trig, welcome in. Good morning, good time zone. How is things where you all are? I feel very close. I feel like the camera is a little too zoomed in. So we're gonna fix that. There we go. I feel better about that. So I'm playing with very snowy, icy, and chilly here. Oh yeah. Well, right here it's still raining because yesterday the temperature rose to 55 degrees, and it's been raining for 24 hours. And the temperature over the course of today is supposed to drop down to -10. This is all Fahrenheit, by the way. I could do the math to do centigrade, but that's what Google is for at the moment. Look, I'm just gonna turn off the spam protector because apparently I made okay, so okay. If I can spell. Alright, so theoretically that should work so that now it doesn't catch pretzel every 30 seconds. Because, you know, you wouldn't want that to be a problem. Yeah, so it's gonna drop, and we already have, and we're also coastal, so we already have a lot of flooding. Like, the Long Island Sound is 7 houses that way from my house. It's like literally right down there. And it will, oh, now it works. Okay, see, we fixed pretzel. We made pretzel and Nightbot like each other, which I feel is a success for today so far. But it's already flooding, and the storm surge is such that it's already coming up. The waves are crashing over the beach, and they're already into people's lawns. You know, we're gonna be fine, unless, like, we don't get water up to our house unless there's, like, a hurricane level event, and we don't have that much. That's not gonna happen. But it's already that much water, and it's going to freeze over. Which is gonna be great. Right? It's gonna drop down to -10, and all that's gonna freeze, and that's just gonna be a great time. For everybody. Or nobody, as the case may be. But, hey everybody! I am your friendly neighborhood Prax. Welcome in, everyone. How are we doing? How's life going for us? You can see that we're being slightly festive today. I actually got this overlay on Gumroad from a creator on Gumroad. I will put their scale level, put their link in chat. And they make a bunch of overlays. They have some really nice ones that are like this, animated. Most of them are almost free or like less than $5 for like overlay sets. And they do a really good job, I think. I think these are really nice. So, you know, shout out to them. But we are here today because people are panicking. Because people are panicking about D&D, WotC, Hasbro, and the OGL. We'll see this one, yeah, Hawkeye, I've been getting them I've been downloading some of the free ones that are in Streamlabs. This one I got from Gumroad. I've been doing a couple things, and I make a lot of my own. I make all of the overlays for my ttrpg streams. Witcher, Agapia, Zweihander, all of them. I make them all for myself. But this was there. And, okay. This is... People are panicking because they are all concerned about this new 1D&D concept, the OGL, how it's supposed to integrate, how it's supposed to work, and as Nightbot is now telling you, I might not be admitted to the bar yet, but I am an official legal intern, which means I can legally sign documents to be submitted in court, and am a 3L law student who is working specifically in intellectual property and dealing with trademark and copyright and trade dress and patents and what's the last one? That's all of them. And licensing thereof. And the OGL, I've actually written papers about the OGL. And how it works for law school, which have all gotten very good grades. I've worked really hard to do a lot of this. I spend a lot of my time with this. I am also a writer of games. I spend my time looking at the OGL and various other SRDs. So let's talk about how those work and what they actually are versus what people think they are. Oh, also, side note, entirely tangential, but a side note. I got an early Christmas gift because my players are awesome. And I got, you may notice that there's no longer a goal on my Ko-Fi right now. That's because my wonderful players actually got me a stream deck, so I'm actually getting to play with my new toy. It's very fun. Very fun. I'm figuring that out, but that means that anybody, I need you all to make more clips so that I can do one of those fancy like raid video and like intro video stuff, so that I can be like a professional streamer. If you could. No worries if it doesn't work or you don't think there's anything clip worthy. Although, set your clocks and calendars to the appropriate time zone, because starting January 1st, 2023, it is Sunday, a week from Sunday, New Year's Day at 12 p.m. Eastern. I mean, I would take that, Hawkeye. I will figure out how that works too. Anyways, a week from Sunday, 12 p.m. Eastern, right here, going for 12 hours. We are doing a 12-hour charity stream, D&D, Charityvania. I've got 4 crews, 4 teams, four groups of players. 12 p.m., 3 p.m., 6 p.m., and 9 p.m. We're going to try and take on Castle Dracula and see if they can survive. I don't think... I'll be interested to see how many of them survive and how many of them actually get to meet Dracula. And there'll be donations to help benefit the players. Wall chicken, you can donate to give them wall chicken. You'll be able to donate to give them other fancy things. But that 12-hour charity stream running then to benefit the Fisher Foundation and Fisher House Foundation. Sorry, I should be specific when I'm talking about the particular people. Fisher House Foundation. Which provide housing, care, and support for veterans and their families while the veterans receive medical treatment at VA hospitals around the country in the United States. So, let's be festive and talk about the OGL. Entirely tangent. Let's dive into it. Okay. So, first things first. When you go and look up the OGL, which stands for Open Gaming License. And I want to be specific here. The OGL, the Open Gaming License, only applies to Wizards of the Coast Dungeons & Dragons 5th edition. Well, the most recent version covers all editions, but the OGL only only is a license from Wizards of the Coast, owned by Hasbro, for people to create third-party content for the game Dungeons and Dragons. If somebody online, a creator, says, I'm using the OGL to create game stuff for Paizo, Green Ronin, Artel Saurian, any of those, they're lying. Some of those publishers, for their systems, have a license that they will grant. Some of them do not. Artel Saurian, for example, does not, have a license for third-party publishing. Anything out there that is not with the mark and says it's published by Artel Saurian Games, that's tied to Cyberpunk Red, Cyberpunk 2020, Cyberpunk, the original Cyberpunk game, the, Castle Falkenstein, any of that, Witcher TTRPG, none of that is permitted, it doesn't exist, it's not legal, and they will probably eventually get sued. Or they'll get a strongly worded cease and desist because Artel Saurian are nicer people, but they'll get a strongly worded cease and desist. Where they're living in the aughts. I mean, they're living in the knots because... So the OGL is the OGL. Only references WotC, Hasbro, Dungeons and Dragons. That's it. Now, we are going to read through it and we're going to talk about it, but those are the first thing. Number 2, systems references document. Now, there are positives and negatives to systems references documents. When it is tied to a game, to a license, like the OGL, a systems reference document is beneficial. If, however, you are a certain indie creator who published an SRD that basically just said, that specifically says you are permitted to use our mechanics if you publish and say it was X, Y, and Z, they're messing with you. And they want you to believe that they have rights that they don't have. Because in the United States of America, and most countries worldwide, actually, let me rephrase that, all countries worldwide, mechanics of a game are not copyrightable. They are not subject to protections of copyright. You cannot go, the rolling of a d20 and adding skill-based modifiers is not protected under copyright. All of this is true. We'll get back to we'll talk about SRDs and why they don't always work later, but let's talk about what the OGL is, and then let's talk about, well, actually, let's talk about why we actually are talking about this at all. So let's go, there was a announcement, okay, so on N-World, Trooper posted this and was talking about it in his stream last night when he was playing the Long Dark. This is published at Wednesday at 6 o'clock, so yesterday, local time, by N-World. And this bothers me so fundamentally, because the author of this... Hello, Scott, welcome in. We're talking about what the OGL is and what it isn't, and why you should never listen to someone who is not either a lawyer or a legal intern or someone who actually has legal experience about what a legal document is and is not. Okay? Okay? Oh, welcome in, Conti! So, this was published, and the author of this article, hello Malkadoshian, hello everyone! Never sign a contract without a lawyer, never sign something you haven't read. You wanna know what, the one problem with that, Scott? Everyone in this chat, I guarantee you, every single person on this chat, in this channel, on this platform, has signed a contract without actually reading it. More than one. Because I want you to all raise your hand and acknowledge the fact that you clicked I read and agreed to these terms on a TOS document on some platform or website at some point in your life. Exactly. Faye is sitting there going, they're a lawyer, and they have signed countless documents without reading them. You've clicked that TOS button. A TOS is a contract. A TOS is a legally binding contract. By clicking that button, you've agreed to all of the terms and conditions that are in that TOS. Welcome to contract law in the United States and worldwide. Now, I would like to preface this by saying I should make another caveat. I have a lot of training right now in IP law. But most of that is in American IP law, but I do have some understanding and training of European and Japanese and the effects of Chinese IP law on American products. The Chinese IP law I have not spent a lot of time in. This semester I worked as an extern for a global corporation. They have offices in the United States, in South America, in Germany, France, and Japan and China. So I've read through all of the documents and understand how that corporation's issues with patent and trademark law work worldwide, which has given me a really good understanding of how the processes work worldwide, but I can't guarantee that everything I know. I'm going to preface this and say I have a much greater understanding of American IP law and European IP law, because the EU is the thing that everyone's going to have to deal with. China, and then Japan I have some rough understanding of. Welcome in, Shinobi, welcome in. Yes, the TOS, everyone's most foul foe. But a TOS document is a contract. Clicking the little square that says you've read and agreed to these terms is a signing the contract with a TOS. Now, there are lots of statements and discussions we could have about the morality of forcing you to sign a TOS when you have no negotiating power in a contract and whether that contract should be morally enforceable. But as of right now, according to existing existing law, it is, and that's been an established point. So, while it is advisable for major purchases in your life, major events in your life, your will, your purchase of your first house, your purchase of your family car, maybe not your first car that you're buying, get a lawyer to read the contract before you sign it. You're gonna do it as best you can. However, my problem with this particular article is that the author of this article, from all of my research into them, is not a lawyer, has never been to law school, admits that they don't know anything about the law, they just work in a company. And they're making statements about what WotC's announcement about what will be in the new OGL means. Okay, so that's 3 problems right there. Number 1, you don't actually know anything about the law. Number 2, you're basing this off of a document, off of a licensing agreement, which is what the document is called. It is called a licensing agreement that hasn't been published yet. Based on my reading of the announcement, it may not even be finalized in writing yet. Probably because their lawyers take the holidays off. but based on their timeline of getting it out, yeah, this is under writing. This is under, you know, they're looking at the wording and getting it reviewed, but it's probably not finalized yet. And you're trying to, so they don't know the law. They don't know about the document that they're complaining about, and they don't know what they're taking their complaints based on an announcement, which isn't even the document, right? It's an announcement that probably doesn't actually contain everything that's going to be in there, and they're just wrong. This article is wrong. And if I were a person that would actually go onto one of these threads and didn't want to get shot down and wanted to engage with these people, I would go onto this and post and be like, hey, please stop. You don't know what you're talking about. You're not helping the situation. Just stop. Jim says, yeah, I remember the first few times I saw a TOS, I read through it. I think it was in the late 80s or early 90s. But it wasn't long before I just started skimming them. These days, at best, I pretty much take a quick glance in case there's a subject heading I don't immediately recognize. At worst, I collapse under the existential exhaustion, consign my fate to oblivion, and just click through. I mean, we've all done it. There's no shame in doing it. We all just need to acknowledge that. Now, there are lots of ways you could eventually argue TOS, but it's not worth it most of the time. So, this article, written by Morris on N-World, states, there's been a lot of speculation recently about WotC's plan regarding the open gaming license in the upcoming 1D&D. Today, WotC shared some information. In short, they'll be producing a new open gaming license. Note that the previous OGL 1.0a will still exist and can still be used. Point number one, no. Just no. That's not the way this works. That's not the way law works. It doesn't. It can't. That's a wrong statement. By the creation of a new OGL, there will probably be language in the new OGL that says it will incorporate and it will incorporate any previous writings, which basically means that the new OGL will become the new standard, and anything that was written before, as in the old license, will be incorporated into the new license. That doesn't mean that the two will coexist simultaneously and that you can pick and choose which one you operate under. That's not how licensing works. Particularly, let me phrase that. That's not how open licensing works. The only way for this statement to be true is if they were individually negotiated licenses with individuals, where WotC would go to, say, Roll20, or Foundry, or One Multiverse, or anybody, you know, Larian that's making the video games, or Idle Champions that's making the video games, and negotiate with them about what is going to be contained in their own specific license. And that specific license will only be a negotiation and a contract between WotC and that particular entity, whether that, you know, Roll20, whatever. They have their own particular licenses. The statement that will still exist and can still be used is just factually inaccurate. No. However, for those of us who use the new OGL 1.1, which will be released in early 2023, there will be some limitations added in regards to the type of product which can use it, and possibly controversially, reporting to WotC your annual OGL-related income. Okay, see now, here's where we're gonna make another statement. It's actually not controversial. It's just controversial because a lot of people in the independent writing, in gaming, like to think that they're somehow not part of actual business, right? Like, an actual business that has a license. Let's say, for example, we're talking about Hershey's. Hashtag not sponsored, but Hershey's Kisses, right? Hershey's can license its the trademark of the Hershey Kiss shape in the silver with the thing, that's trademarked, right? That image is trademarked. The Hershey's name and the Hershey's Kisses name, both of those are trademarked. they can license those to manufacturers of merchandise. And in that license, it will state that they would like that they get to know the total revenue that the company made based on their license. That's a term that can be included in the negotiations of the licensing agreement. What they can't ask for is the actual markup, the actual individual sales the individual price that you give it. You can't ask for trade secrets for the individuals based on what they're selling and how they're producing and all of these things. But you can ask for a raw number to evaluate the value of your trademark, right? Like, if I have a trademark, it's a trademark or a trade dress is considered a piece of property, and property has value. You know, the market will determine how much value that has, but if I have no knowledge of what my value is, then I can't market it correctly. So this is just a reporting feature that will be included that basically says, hey, if you make, and the other thing is, this argument here is about people who make over $50,000, right? Like, do you think that might be one of the motivating factors Paizo had to come out with Pathfinder 2e? I have to check on the timing for this, but 2e came after the 5e OGL. So Paizo 2nd edition 5e was released, the OGL for 5e came out within like a couple of weeks of the release of 5e. They were tied pretty much together. So they came out roughly, and then 2nd edition came out like Pathfinder 2nd edition came out like 3 years after 5e, I want to say. Don't quote me at that, but it did come after. But it more interesting would probably be that it came out whether or not Paizo knew anything about the decision of creating one D&D, and that pushed them to push 2nd edition Pathfinder before one D&D could be announced and therefore discussed. Unstable Diaz, when I choose to publish code, I can choose which license to publish under. I think I can choose between GPL2 or GPL3 licenses, as well as many others. No, see, the issue about the GPL, Unstable Diaz, the GPL license is not the same thing here. You're not really, under the GPL, you're not actually choosing the individual terms of the license. If you actually look at the GPL, we can pull that up. GPL2 and GPL3 don't actually have any major distinguishing features of the license that create them as truly separate concepts. And then there's actually phrasing in them that talks about it being integrated, but it's about choosing specific terms within that license. They're not going to do this for WotC. WotC's not going to do this. And the reason is because the GPL is a publishing license. The open gaming license is about using... This is going to get complicated. And okay. Intellectual property 101. So licensing. A license is an agreement that you are allowed to use someone else's property for your own financial gain based on certain limiting factors. This reporting of revenue is going to be one. Usually if they're into really big names, you're going to be reporting the royalties. Yeah, Unstable Diaz. Both the GPL2 and GPL3 are effectively the same license. The difference, as far as I've understood it, and I have to go back and read them, which we should do, but as far as I am aware, the biggest difference between GPL2 and GPL3 actually has to do with publication location and where it's enforced, and blanking on the other thing. But the actual functional terms of the license are the same. And there's terminology, I believe, in both of those licenses that say that it is, the GPL2 and GPL3 are iterations of the same license. they are, that's just, when they say GPL2 and GPL3, what they're talking about is the original, it's like any software, right? You know, it's like first edition, second edition, third edition. They're just updating the document. And yes, location or enforcement is the significant difference, and as well as the AGPL. Yeah, so it's location and enforcement. You can't, because of that, you can make the selection whether you're going under 2 or 3, because it has to do with location and publication. This document that's going to be coming out is because we'll go through what has actually been announced by WotC and why this whole statement is wrong. You won't be able to pick and choose. It's just backwards compatible. I bring up Paizo because 1E was under the DnD 3E OGL. If that was superseded, there would have been a period where they were public. No. So, Jim, it's not that they're publishing illegally. It's just the gaming. What happens is each license for the OGL, each time the OGL was been updated, right? It's incorporated. You know, they say it's like, well, the OGL for 3rd edition, or the OGL for 4th edition, or the OGL for 5th edition. That's great. It's effectively the same document. And the additions are all going to be permitted. And each new edition that WotC puts out of the license includes language that makes the previous license still valid and usable. It's why you can still create publications for 3rd edition. It's why you can still create publications for 4th edition, if you so chose to. You know, it's not that that you are choosing to use the 3rd edition license or the 5th edition license, and whether or not the 3rd edition license would apply, you know, would be, if you were making things that would fall under the 3rd edition license, whether it would be valid if the 5th edition license is the one that exists. That's a non-issue at this point. Because what Paizo is really using, again, remember, mechanics are not copyrightable. So the biggest thing that before Pathfinder 2nd edition Paizo was using, while WotC had 5th edition before the release of Pathfinder 2E, were stat blocks. That's it. Because the mechanics cannot be copyrighted. Expressions of the mechanics can be. And that's what most people in the OGL, why they want to use the OGL. Because the stat block, right? The stat block is an expression of the mechanics. It's an easy expression of the mechanics, and it's something that a lot of people understand. Also, the terminology and names for spells, all of that, it can be copyrighted. But the actual mechanic of rolling the dice and what the plus or minus and how that is affected, that can't be copyrighted. So the release of the 5th edition OGL incorporated everything that previously existed under the previous OGLs, which is what the new OGL is going to do. It's the same thing. You're just going to incorporate the new one, and you don't really get to choose. The GPL is different. We'll come back to the GPL. The new license is going to incorporate the terms and conditions of the previous license. Like, for example, it will include things that say, you know, if you're publishing 3rd edition, if you were originally, you know, when publishing our 3rd edition products, you can continue to use it. When you're publishing 5th edition products, you can continue to use it. It's even less likely to be an issue here because of everything that WotC is claiming. Again, we don't have the actual license to, and so this is my giant caveat that the license could probably say something entirely different. But the actual license, the words on the license, we don't have yet, so we don't know the actual terms. But WotC's announcements have all been that 1 DnD will be backwards compatible with 5e, and that it's not a new edition, it's just tweaking things enough for one D&D and more integrated play. So in that case, it's probably just a new version of the license that is existing and not actually changing underlying main things. Now, it's changing individual terms. And again, most businesses already include some way of stating, I need to know how much what your revenue, not what your profit is, but what your revenue was on my product, so I know what the value of my product is, so if I license it to someone else, I'm in a better negotiating position. That's what it is. That's all this reporting on your annual OGL related income, revenue. And we'll get back to why that's not controversial. That is a normal business standard action. People in the game development sphere, particularly in the ttrpg game development sphere, like to think that they're special. They're not. Indie games in particular like to think that they're special, and indie publishers like to think that they're special, and they're really, really not. Like, I love me some indie games, I love playing them, but you are engaged in a business, and you have to engage in the business in which normal business practices exist. Hi, there's an entire subset of law dedicated to this. It is called the Universal Commercial Code. It is a thing. It is a massive thing. It is a massive breakdown of basically the courts saying, you know what? We have these laws that we basically have come up with through, centuries, but they aren't really what businesses do in the real world. So somebody sat down and made a list of what people actually did in the real world. And then they created what is called the UCC, the Universal Commercial Code. And I believe every state in the Union has adopted some version of the UCC. The practicing lawyer in chat might be able to confirm, but I am 100% positive 90% of those states in the United States have adopted it wholesale. I believe there are a couple states, California, Hawaii, and Delaware, that have adopted certain modifications to it, because they're all very special places. Oh well. I'm not. Oh well, Faye. But you will acknowledge that the UCC does exist. I was talking about that, but hey, just because you're no longer practicing doesn't mean you're not a lawyer. It just means you're no longer practicing. You're in a place that may or may not be better. Excuse me. So this universe. Indeed, I took a whole ass class on it. Yep, so did I. Well, it is better for you. Okay, that's fine. The UCC is a class that most people have to take. It is a major thing on the bar exam in most states. And, the people who like to claim that they are not buyers or sellers in commercial goods, hi. Your game you're publishing out there and you're publishing and you want somebody to pay for it, that is a sale of commercial goods. You are involved in commerce. You are now subject to the UCC in your state, and or the federal adoption of the UCC, which is even worse. Because it's a mess. Well, mostly. They mostly adopted it wholesale, and then California screwed things up. Unless you're Lloyd Drubler. Dobler. Yep. So you are engaged in commerce. WotC is engaged in commerce. Individual publishers engaged in commerce. Everybody who's got a page on itch is engaged in commerce and counts as a seller. I'm one as well. Faye, don't want to sell anything, buy anything, or process anything, anything as a career. I don't want to sell anything bought or processed, or buy anything sold or process anything sold, bought or processed, and repair anything sold. But yeah, exactly. Go live in the woods and enjoy just subsisting on what you yourself can make, farm, or eat. Other talk. Jim says, I realize they're saying it won't be a new edition, but I'll admit the one D&D branding is reminding me a lot of D&D Next, and as I recall back then, they also said they wanted to get away from thinking in terms of editions. until the thing comes out, I shall look askance at it. And probably afterwards, to be fair. I mean, yes, that is entirely fair. It is, for all lack of... I mean, we haven't seen the finalized version of it, but everything that I've seen so far is, it's a new edition. Just call it a new edition. I understand you want to go away from calling it a new edition because you don't like the edition war concept that exists. Suck it up and just reprint old things because you might make more money than what you're doing with, you know, other choices that you're making financially. So this Morris's person's argument that it is controversial if you make over 50, and they leave out the important part that there's a number related to that value. If you make over, I believe it's $20,000 on revenue from the OGL, you're gonna have to report it. Or no, it's $50,000. Okay. I don't make anywhere near that much money on things I publish under the OGL. Ain't gonna happen. They're also adding a royalty for those third-party publishers who make more than $750,000 per year. Yes, you make more than $750,000 on WotC's product, they are going to charge you a royalty. You do not have an exclusive license. You have not paid them a massive royalty. Their royalties on licensing agreements are actually, you know what, really, really common. Because how else are they going to benefit financially from the use of their license? Which is the function and purpose of having a license. As I may have spent a lot of time working about, one of the core functions and purposes of granting a license is for the product that is for the license to being used and exploited and creating benefit, whether in good faith business, good faith and or financial gain. If you're benefiting $750,000 a year just on WotC's product, then you're benefiting financially from their good faith that they've already established within the community of a business product. And when I say good faith, I do not mean positive community engagement. I mean the good faith understanding that the product is what the label on the product is. That this trademark goes with this product, and you recognize the D&D trademark symbol on a book, and you immediately make the connection of, oh, this is tied to that game that I really like to play. Therefore, this book must be good, and therefore I should buy it because it's tied to the game I really like to play, as noted by the really big trademark symbol and or the like rule the gate OGL license, the words inside. This is a thing. Or even just this marked an art's value, whether you like D&D or not. Exactly. Like you may not like D&D, but you can sit there and say, oh, that mark of the D&D on the book means that it has the same value of people who might enjoy D&D as other people. Whether you enjoy it or not, you recognize the value inherent in the mark. That is what trademarks do. It's tied to a mark in commerce. Hi, we're having fun. Are we having fun yet? Also, I love reading everybody's comments in chat. Really appreciate it. If you have an actual question, just put question in front of it in all caps. It'll make it slightly easier for me to see. Is it more likely to be $750,000 per product or an aggregate? Also, is it only the products which fall under this license, or all the licensing products, including that which aren't utilized in this? No. So let's actually look at we can look at their we can look at WotC's announcement. That's actually D&D statement OGL. Okay. Yeah, stop. Okay, give me the actual link to the actual document. Not the gamer, nobody's rant. I just want the Okay, why? Okay. Okay, here we go. On D&D Beyond, because they own D&D Beyond again. So let's look at what they actually say in their statement. Again, prefacing this by saying we don't know the actual words of the license. This is just what's being reported through their PR department, and has probably been a very watered down version based on what their corporate lawyers have told them that they are allowed to say and what they're not allowed to say, and probably doesn't actually include any hard statements one way or the other because they don't want to be contradictory, because it would make a level of expectation. So will the 1D&D include an SRD or be covered by an OGL? Yes, we are designing 1D&D with 5th edition backwards compatibility, so all existing creator content that is compatible with 5th edition will also be compatible with 1D&D. Second, we'll update the SRD for 1D&D as we complete its development that is informed by the results of playtest and everything else. So, they can't update the SRD or the OGL for the new product until they've published the new product. But everything that is covered under the current OGL is going to be covered going forward. You can still publish and write everything that you could publish and write before. The caveats and changes, at least where they're being reported on this document, are in different places. Now, if we go back to the article here, that the previous will still exist and can be used. That's not what they're saying. They're saying that it will be backwards compatible, and the new document will incorporate the old document. It is backwards compatible. That doesn't mean you can pick and choose. It means that there's a new document that will be existing. Yes, we will release... Okay, will the OGL terms change? Yes. And to be frankly fair, they have to. The way the OGL is written right now is very interesting, but I was very confused as a new law student why it didn't count as what is called naked licensing. And Creative Commons also falls into this. So a naked license is a term that the courts apply when an IP holder licenses a product too broadly. Trademark and copyright and patent law say that a person who owns an intellectual property, it's the bundle of sticks, right? Is the comparison. You have a bundle of sticks, and if you own those bundle of sticks, you can choose to do what you want to do with that bundle of sticks, whether that is share them, hoard them, sell them, make profit off of them, whatever you want to do, but that bundle of sticks is yours, and you can choose what you want to do with it. But there are certain caveats that go with that. In licensing, one of the expectations to balance out the enforcement side, of the license is the expectation that you will police and protect your license. So for example, going back to our Hershey's example, Hershey's creates a trademark around the Hershey Kiss shape in silver, that conical shape of a Hershey Kiss in a metallic wrapper with a paper flag coming out of it. That image is trademarked. There are like 25 different images that are tied to it based on each of the different seasonal pictures that they do, right? But the core silver one is the most common. If they then license that image to someone who's manufacturing stuffed animals, or they license that image to the producers of Candyland, or they license that image to the producers of a video game, or they license that, or developers of a video game, or they license that image to, something else. If they don't go back to a to the people that they licensed to, called the licensee. If they do not go to the licensee and say, hey, what are you doing with our product? Or, hey, we don't like you using the image of the Hershey Kiss as, you know, Pornhub, we really don't want you using the image of the, we see you using our image and our trademark. You can't do that. We're gonna for enforcement. By not enforcing the use or policing the people who have the license, it can be considered what is called naked licensing. And when naked licensing happens, the courts basically look around and say, well, you don't value your product, you don't value your property, and you've just basically been giving it away to everybody in around, and so we're not going to let you to continue enforcing it. So, here on the OGL, the new terms and conditions, I guarantee you, were probably suggested by the lawyers that basically said, hey, your OGL is really broad. I mean, it isn't, but it is, because there are almost no way for the creators of WotC to police the publications of individual documents under the OGL. So Hawkeye has a question. I'm in the process of creating a homebrew adventure that I hope to publish. Would it be smarter to wait to the release after this new stuff is released, or will it be okay, safe to publish? I mean, they're saying the release date is early 2023. If you think you're going to be done before the OGL, the new OGL version comes out, publish it under that. Because here's the thing. Anything that's pre-existing at this point, it's operating under the current license. If you are operating in good faith under the current license, they can't go after you for anything that happens going forward, because you are operating under the terms and conditions and the contract that previously existed. When the new license is created, it's a new contract, and the new terms you will have to abide by. That's not a bad thing, and I really don't, honestly, Hawkeye, if you want to wait and just read through the new terms and see if there's any major problems, it should be fine. Because I don't think you're actually going to, based on what they're talking about here, I don't think you're going to fall into any of the traps that they're creating. So, as they say, the reason they're doing this is because of the creation of third parties to mint and D&D NFTs and large businesses to exploit our intellectual property, which, to be fair, Paizo is effectively doing. But at the same time, that's if Paizo is publishing under the OGL without an independent, negotiated license, which I'm pretty sure at this point Paizo and WotC have done. Yeah, tort law is fun and just, you know, you have to be, you are subject to the law as it was written and created at the time the thing was created and published. That's what it is. So Morris, going back to this other document, is like, interestingly, only books and static electronic files like ebooks and PDFs will be compatible with the new OGL, meaning apps, web pages, and the like will need to stick to the OGL. That's not what they mean. They mean that this document, so this is what is going to happen. First, we are making sure that OGL 1.1 is clear in what it covers and what it doesn't. OGL 1.1 makes clear it only covers material created for the use in or as ttrpgs, and those materials are only ever permitted as printed media or static electronic files like EPUBs or PDFs. So, the license only protects things that are created for use in or as a tabletop role-playing game. Any of the adventures, any of these books on Kickstarter, any of these supplements that are on DM's Guild, any of these files or folders or basically, you know, subclasses that you have created, magical items that you have created, anything that's using the spell system, you know, villains, all of that. Those are all going to be static. They have to be what is considered static and unchangeable for the purposes of definition under what is called the Sedona Conference. It's about the use of electronic files and e-discovery in litigation, but they created a really big explanation about what it counts as files. in printed media is going to be the general thing. Other types of contents like videos and video games are only possible through Wizards of the Coast fan content policy or a custom agreement with them, which is what it already counts under, right? Like, the OGL doesn't cover Idle Champions. The OGL doesn't cover Baldur's Gate 2. The OGL doesn't cover your fan vid about how great Driss is, or your rant on YouTube about whether or not the this build of this particular cleric is better or worse. That's not what the OGL covers. You are not publishing game content because under the OGL for that product. That's fan content. That's subject to the fan content policy. That's been subject to the fan content policy for years. The interesting people who might be affected by this are wikis. But wikis have always been a very dark hole, because technically 90% of them, if they make profit, are in violation, right? Like, they are infringing. Now, whether or not someone chooses to go after a wiki for infringement is a separate issue. That's a whole separate issue. But fan wikis are... Now, the statements written in the fan wiki, if it is taken, copy and pasted from an original document, then it is in violation of copyright. If any of the images are reproduced, they're in violation of copyright. If any of the stat blocks are reproduced, they're in violation of copyright. They are all infringing. And theoretically, the rights holders could go after them. 9 times out of 10, none of the big people are going to go after a wiki, because they're not actually making money. They're making cost, effectively, to maintain it. And it provides better things. But torrent sites, various other things, they'll probably go after them in this new. Question: how does updating a product affect the licensing? If a product has been published using a previous license, will an update necessitate updating the applied license to the new license? I'm going to be that wonderful lawyer and say, it depends. If someone will clip that, because I want to make that a GIF. It depends. And make sparkles out of it. Normally, if you were, say, to be publishing a textbook. So here's the thing, Unstable Dios. Okay, you want me to full screen? I can do that. It depends. So, if you are considering, that you have, say for example, the Uncaged anthology, right? The Uncaged anthology, which I am a writer on, there's a really good anthology of adventures, where with the feminist reimagining of the female monsters in the Monster Manual. Look it up, it's on the DM scale, really great things. I'm in volume 1, but there are 4 great volumes that have some really great adventures from tier 1 to tier 4. Lots of fun stuff. If, for example, the version that the authors of Uncaged wanted to update the version of the public of Uncaged. Thank you, Conti. You should be able to drop the clip in the link if you want. If the publishers of if the writers of Uncaged wanted to create an updated edition, thank you, Conti, wanted to create an updated edition where the update was effectively minimal, grammatical edits, changing, adding art, tweaking things. You're not changing the structural, you're not changing the inherent content of what you were using under the OGL. that update would probably not need to be incorporated under the new rules. If you decided we want to take Uncaged and change the mechanics to fit, you know, make it Uncaged a second edition that would be under the same, you know, take those same adventures and have it apply to the new 1D&D, then yes, it would have to be under the new rules, because you're using the new rule set, right? Like, you're using the new mechanics and rule set that are going to go under 1D&D. But that's why this OGL is important, because it's already saying, hey, you're only writing for this 5th edition. We're incorporating everything that came up to 5th edition. You don't have to change anything. You don't have to make a new update. That's not an actual update that would need to happen. But Faye says, someone suggested I start an Etsy page and sell my Critical Role themed Ronkinol. I don't know how to say it. Ronkinoli knuckle. Ronkinoli. I don't know. Boards. I honestly don't know how to say that, and I apologize. Crokinoli. Crokinol. Thank you, Faye. I doubt they'd care for such a small thing, and it could be that it counts as transformative, but it's not worth the hassle. Yeah, exactly. Like, there's the argument. See, here's the argument that people would, and Faye will agree. Fair use, people like to stress that transformative is the be-all and end-all of fair use. It's not. It is, like, actually the bottom rung on the 4-prong test of whether or not something is it counts as fair use. The number one of which is how much of the original product are you using? Number two, is it likely to cause confusion in the market with attribution, i.e., does Critical Role already involved in a market for board games and or similar games, in which case, yes, they do have the Ukatoa board game, so there could be an expectation the courts would say, hey, the CR people, the Critical Role people would be like, I might choose to go into creating Crokinole boards. Most people are not going to do that. They're not. Critical Role is probably not, short of based on their fan appreciation and things. Unstable says, and that's the logic which prevents me from publishing a stub under the current license and then updating it with all of the actual content under the then old. Exactly, right, exactly. Like, you can't just publish, I'm going to publish a placeholder, it needs to actually be a published document. You can't then just go up, you know, and update it. Because if there's nothing under the content that you're publishing, then you're not actually publishing, and you're an entirely different problem. But in this case, you're definitely going to be going in and be like, okay, the original document already existed. The updates are minimal, grammatical, possibly rechanging things, adding new art, or we found out that there was an error in the math, we're going to update and fix the math. All of those would not be an issue. We want to change it to the entirely new rule set and system that's coming out with this quote-unquote 1D&D, then yeah, you're going to have to republish and use the new rules. Okay? When people get upset about that, it made no sense to me. Will this affect the D&D content and services the players use today? It shouldn't. The top VTAT platforms already have custom agreements with wizards to do what they do. Interestingly, only books and static files will be compatible, meaning the apps, web pages, and the like will need to stick to the No! The apps that are already existing in an app store for sale already have a license. They have their own independent license. Roll20, Foundry, Idle Champions, Larian, all of these people have their own license. They were never operating under the OGL. They couldn't operate effectively under the OGL. You know, D&D merchandise like minis and novels were never intended to be part of the OGL, and OGL 1.1 won't change that. They're not under the OGL now. I'm like, I'm sorry. Creators wishing to leverage D&D for those forms of expression will need, as they have always needed, custom agreements with us. Exactly. Oh, yeah, thanks. That I was talking and pointing to things. Okay, so we were down here. You know? D&D merchandise like minis and novels were never intended to be part of the OGL, and they're not currently part of the OGL. We'll look at it and explain to you why this is true. Creators wishing to leverage D&D for those forms of expression need a different, as they have always needed, custom agreements. Like, if you want to use the image like any of these character images, any of these, like, any of these plot points, you know, maps, any of these things, for financial gain in a form of media that is actually not actually tied to the production of a ttrpg, that was never covered under the OGL. It wouldn't have been covered under the OGL. I don't understand why people would get upset about that one. Second, we're updating the OGL to offer different terms to creators who make free share-alike content and creators who want to sell their products, which is fine. It means that they're stressing the difference between people who are not actually technically infringing because they're not making a profit. Which is the biggest thing about fan-created works and how that actually... But again, so share-alike content that you post for free, anything like that, is going to be treated differently than content for sale. Okay. It's it is what it is. These are things that are going to happen. These are things that are going to be true. You're not going to change the rules. These are rules that should already be existing, but apparently weren't. We're going to go back and look at the OGL and find out where exactly they meant. So if you make share-alike content, very little is going to change for you. If you're making commercial content, relatively little is going to change for most creators. For most of you who are selling custom content, there are new things you'll need to do. Accept the license terms and let us know what you're offering for sale. Okay, number one, you already had to do that. And most people who did it merely through publishing through the DM's Guild, right? If you published on the DM's Guild, which was the most common platform to publish upon, you already accepted the terms of the license, and you were inherently, by publishing on that platform, giving notice to WotC that a product existed. I'm betting the reason that they're putting this out there is so that they have eventually will have that will probably be incorporating a right to say no. You can't use our likeness, image, trademarks, copyright, whatever on this particular product because we think it objects to our morals. Which, hey, guess what? The TOS of DM's Guild already does. Now, mind you, the TOS on DM's Guild is very arbitrarily enforced and very essily enforced, as was proven by certain products a couple of years ago. Yeah, jumping ahead, reading the intention, always a dangerous break. The 50k is an OGL aggregate and the 750k is the global aggregate. See, I don't think so, right? Like, if you make, they're saying if you report the annual for, if you make more than $50,000 a year, you report the OGL related annual revenue annually. And because so for lawyers, unless previously stated, you're going to continue using the operating the same terms. Because it was already established that it's about the OGL related revenue, then it will also be, if you make $750,000 in income a year in OGL related revenue, you're adding a royalty starting in 2024, which is a whole extra year. So even the creators making significant money selling D&D supplements and games, no royalties will be due for 2023, and all revenue below 750. Yeah, see, it's this. This is the statement. It's revenue below $750,000, which is based on the OGL. So if you are selling something under the OGL and you're making $750,000 selling WotC's product, they're gonna ping you for a royalty. That's just what they're gonna do, which, you know, is not, again, not uncommon in the course of business. Which is a thing that exists, right? Like, doing business in the world is a thing. So this goes back to this statement. There will, of course, be a lot of debate and speculation over what this actually means for third-party creators and how it will affect them. Some publishers, like Paizo and others, will likely simply continue to use the old OGL because it will be integrated into the new thing, and so let's put it this way. Paizo is one of the companies that's making $750,000 a year. We know that, right? Like, we can stand there and say objectively that Paizo is one of these 20 people, 20 creators. Hello, Ice Bunny, good Yule to you. You can see I'm also being festive today. Gnome, welcome in! Hello, Raiders, welcome in! We hope you are welcome. Come on in, have a seat. I am your friendly neighborhood Prax. Welcome to the channel. I use she, her pronouns, and we usually do a lot of, chatting and ttrpgs here, and we also do a lot of I do random video games. Hello everyone. Hello again, hello Gnome. Hello everyone. Hello Lightning Invoker. Welcome in. Thank you for the wonderful raid. Hello Sphinx. So I am here today because certain people are panicking about the OGL, and I, well, not yet a lawyer, am however a law student and a legal intern, which means I can legally sign documents to be submitted in court. So we're talking about what the OGL is and what it isn't and what it never was. Because sometimes I don't think that does not mean what you think it means is a very true statement that needs to be enforced. Hello everybody. The OGL is the open gaming license that, and I want to be very specific here, OGL, the Open Gaming License, only applies to Wizards of the Coast Dungeons & Dragons. It's how third-party people can publish content for any of that. There are other publishers that have their own licensing systems, but only D&D has an OGL. Has the OGL. Like Free Leagues has what is called an SRD and a license, but it's not the same thing. It's why third-party publishers can publish things in existence and conceptually, but a lot of people are panicking, and there was an article yesterday that popped up on N-World that what is the real word for it? No, it's a license. It's a license is a permission given by the rights holder of something, usually in this case an intellectual property, copyright, trademark, trade dress, trade secret, patent, and sometimes domain name falls under there, but it's not usually. Hi! Sorry about that. I tried to drink water and talk at the same time, and that wasn't gonna work. But, hi! So, we, words. Okay. So, a license is an agreement between the rights holder and someone else to use the product, the property, whatever, and the, breathing water is never easy. No, I don't recommend it. I don't recommend it at all. Although the Stream Deck aspirates live on Twitch, you know, the Stream Deck is a wonderful thing. I'm very, very happy that my friends got it. Hello, Simon. Welcome in. Thank you again. Simon and the Witcher crew got me my new Stream Deck, so they are wonderful, wonderful people, and I really appreciate them. But the OGL is a license, and the license allows someone else to use your property for financial gain with your permission. And you have the right, under a license, to say, no, I don't want you using it that way. Yes, if you use it, you have to let me do this. And if you use it, you have to pay me certain things for it, depending. So, this article on N-World, written by Morris, is just... people posted it, and the trooper was talking about it, and it doesn't actually stay. The article is wrong. Factually wrong. Yeah, Icepenny, so if I allow someone else to use my product in this agreement, I can say, and in the case of Wizards of the Coast, OGL, and their announcements about what the OGL is going to be for one D&D. If you make $750,000 in revenue selling a product related to the OGL, they have the right to charge you a royalty. If you are making $750,000 selling WotC product, they have the right to charge you a royalty according to the new rules. That's not uncommon. If you participate in business at all, the use of a license and charging someone a fee is not uncommon. You can say that. It's allowed. But this article gets very, well, some publishers like Paizo for Pathfinder and others will simply continue to use the OGL. This is a statement that is wrong. This statement is factually wrong. Because the old OGL will not continue to exist when the new OGL goes into place. The new OGL is basically going to incorporate the terms of the old OGL and say that it is this exists, so we're going to take it, and the old thing exists, the new thing is coming in, everything that was in the old thing is going to get pulled into the new thing, but there are new terms that are going to supersede. So Paizo will still be subject to paying a royalty under the new rules, because, look, we can all acknowledge that Paizo is probably making more than $750,000. And Icepenny, the question of fan art falls under it depends, right? If it's true fan art, where all you're doing is creating fan art and putting it on the internet and not charging anyone for it, hi, this is the true definition of fan art. If you are not charging someone for it and you put it out there in a published form, in a published media, then it is what is it is a defensible infringement of the license using fair use. Fair use is a defense against infringement. But to use the fair use defense, you have to acknowledge that you don't own the rights to the thing, that you are using the thing, and that someone else has the rights to the thing, and they have that, and you're using it, but it's okay because your use of it is permitted under fair use. Oh, Ice Bunny, artists at cons have been... If anyone actually went after any of those artists with any real, you know, sent them massive cease and desist letters, all of them would be in violation. Like, so for example, the wonderful, fabulous artist on this channel, the wonderful Hanimation Art, she did the art for the Witcher Road's Home. What she created is considered fan art. She also goes to cons. If any of the rights holders of any of the art that she created for particular video game characters wanted to send her a cease and desist letter and tell her not to sell them, they can. It's why she doesn't have certain charms that she sells anymore, is because, you know, rights holders are a thing. It's why most fan art aren't going to go after anything owned by the mouse. You know, people who sell anything at a con isn't going to go after anything owned by a mouse. But in this statement, the author is implying that Paizo, who makes way over $750,000 a year, could legitimately just go, well, we just want to continue operating under the old license, so that means we don't have to pay you any actual royalty. I'm gonna call bullshit on that. That's not how that works. That's not what the law says. That's not what... That's just not how it works. Now, the other caveat on this is I pretty much guarantee at this point Paizo has a separate licensing agreement independent of the OGL with WotC, just based purely on size and publication, right? Like, that would be a thing. But yes, if you have any questions and you want to know more about licensing agreements or patents or trademarks and how it reflects on why the fact that 90% of those SRDs that you see on indie ttrpgs are not worth the paper they're printed on, go ahead and write question in all caps in the chat or highlight it, either one. It will help me find them as I sit here and do this myself. But, so bottom line, how hard is it to get a patent? In the United States or worldwide? Because the answer is, the United States it's hard, but once you have a US patent, it's a lot easier to get patents worldwide, because there are a number of international treaties that make it easier if a patent exists in one country to then patent that same thing in a different country. If it meets the patent requirements for that country, or the EU. And the EU is just weird. Europe has a separate patent office that's not part of the EU that covers the continent of Europe plus the British Isles, not just the member nations of the EU. It's complicated. And just so you know, the rough estimate number on filing a patent application these days, filing, and then any of that. No, the US is still first to file. The US is still first to file. The US Patent Office is first to file, and then, which is an important distinction, and why the, it's versus their trademark, which is first in use, but first to file. And which is why if you file because even if you can file a US patent that hasn't been granted yet, you can still use that as you can then, it helps you with filing an international patent. It gets very interesting. But, so yes. So the DMs Guild, okay, see, Ice Bunny, that wouldn't be a patent. was asking if they would hard because I was thinking if ex-indigenous people could patent the cultural stuff so they could go after companies using the stuff belonging to them. See, that's a... No, because a patent has to be an invention or a creation. That would be... What that would be seeking of protection would be either a trademark or copyright. Trademark, however, in the United States would be based on the first use in commerce, so a corporation using an idea or aesthetic or something culturally that belongs to a certain indigenous group would be, well, the indigenous group didn't use it in commerce first, therefore the corporate people who use it in commerce first would be subject to it. Copyright is unique. An argument could be made that for violation of copyright, because a copyright is anything that can be created or artistically created into a published media, and copyright attaches at the moment of creation. It doesn't require a registration. However, in the United States, registration of copyright is almost always necessary for accurate enforcement at a federal level. Some states will let you enforce copyright if it's not submitted to the Copyright Office. I mean, you don't have to, right? Like, I could write a poem live on this stream, and it would be subject to copyright protection because it was my idea published in a medium that could be transformed and understood and recreated. And I would have copyright protection on that poem. But copyright is not the same thing as trademark. A trademark, again, it has to do with a mark used in trade. A trade dress, the way something looks as it is used in trade. All of these things are a benefit you know, in the long run. And it's funny, applying intellectual property rights to a cultural idea is probably not going to be subject to copyright, right? Because it's a cultural expression and it doesn't have an individual creator. So for example, in the United States and most countries worldwide, excepting Australia, although that is currently under review and challenge, AI cannot be the listed creator for a patent, a trademark, or copyright. Artificial intelligence cannot be a trademark, copyright, or patent holder. They just can't. So, the programmer of an AI may receive copyright protection for the program of the AI, but the AI itself cannot own property. And a culture, right, like, and a whole group of people would need to prove that they are the creators of X thing. Specifically them and not their ancestors. Because if you're going to argue that, for example, let's use my cultural ideology. My mother's family is from Sicily, my father's family is from Ireland. I cannot claim that I should get a patent or, you know, a patent on any of the works of creations of Harmonides, even if he is an or any of the Sicilian architects that created the ruins of Syracuse. I can't argue for that because you want to know what? That would be in the public domain. So a lot of people who would wish to claim certain cultural practices, ideologies, or whatever have to prove that they created it themselves, that it's not public domain, and I don't think, like, this is just not this isn't a thing you can really do in this medium. That's not what this creation is for, right? Like, intellectual property protections, trademark, trade dress, copyright, and patents are to protect creators, designers, artists, all of these things. Now, some people like to claim that there is an inherent problem with copyright. It exists and we shouldn't allow it to continue to use, and there are people who abuse it. Yes, but there are people who are aggressive in their enforcement who maybe consider it possibly, others might be abusing their copyright. And there are people who abuse and argue that they have a copyright when they don't. You see a lot of that now with the DMCA and how the DMCA is being integrated on certain platforms like YouTube, Twitch, whatever. But the existence of copyright protection, the existence of a patent, the existence of a trademark is a good thing. Question from Unstable Dios. Why can't, in the US, IP be explicitly released into public domain prior to its otherwise transition? Because of what the definition legally of what public domain is. And Unstable Dios, a creator can create something into the public domain. And can state, it is what is called the Creative Commons license, which is a giant naked license, it effectively is. And it is basically a statement of waiver, where you're stating, I am creating this thing and I am putting it out into the world, and I am choosing, even though I have the right to enforce my protections upon it, I am choosing to put it out there in a media and form in which it is open to everyone. It gets fuzzy. A lot of you have to publish it in certain ways. And, people can. Most aren't going to choose to. If we believe that people should be paid for their labor, right? Everyone should be justly paid for their labor. Then the labor of creating an artistic expression or a creative work or anything should also involve being justly and rightly compensated, even if you're going to put it out into the public world. And let other people use it. Like, okay. I mean, it's a question, but it's a philosophical question about whether or not you deserve, if the creator wishes to share that in a means and manner where they do not wish to have protections or benefits over their work. That's a choice that the creator is making. Oh, hey guys, next time remind me to turn the captions on. Totally forgot that. I'm feeling so smart now. You know, like you do. Okay. So does anything prevent someone from creating some IP, using it for a decade, then releasing it all to some relevance? Okay, see, Unstable Dios, the only thing that you're basically talking about patent law, right? Like, a patent in the United States is effectively only provides protection for about officially 20 years from its filing date. Not from its issue date, but from its filing date, which means you effectively get about 15 years out of it, maybe 18 if the patent office is moving really, really quickly. They don't. Well, that's not true. They created a fast line system for the COVID vaccine that got it out in less than 18 months, which is massive. The fact that there was an effective patent that had gone through medical trials that got through the USPTO in 18 months is just mind-boggling. Like, I know people who have filed with the USPTO and don't get the first acknowledgement of the acceptance from something other than the mail department. Not without, you know, eight to 9 months, right? Like, there's a massive shortage of of patent and trademark inspectors, and like, I think the backlog is like almost 2 years now. It's huge. So yes, there can be somebody can create something, IP, and then yeah, exactly. Most chemo drugs take 5 to 12 years to go from patent to market. The vaccine creation for COVID was mind-boggling fast. Both in FDA approval, because they got rapid FDA approval system. They got a modified FDA approval for drugs in the United States for the patent to be. You don't need FDA approval for the patent, although it usually is helpful. The patent inspector will usually accept it more if it never has one. But all of this is interesting and fun, and we were originally talking about the OGL, so we should go back to talking about that. Actually, we should go and talk about what an SRD is and why a lot of those wonderful indie writers that we all appreciate and play their games and want to support have created documents which are entirely illegal and have no enforcement. And you want to be like, I see what you did there, but it's not valid. So for example, let's look at this document. I love For the Queen. I played for the Queen. I have written and created a number of games for the Queen, which you can find on my itch. I have an itch page. You can find all of the games I published there. I have created a number of them. Now, I have followed, because I can, each and every one of these SRDs on the point. But we should talk about the problem with this SRD and why it actually doesn't do what it thinks it does. Licensing for the Queen is now possible with the April 2019 release of our system reference document, using the moniker Descended from the Queen. The contents of the SRD are available for use under the Creative Commons Attribution license, which is a creative license, which basically means that you are creating it, but you're using it, and then you have to give attribution. Hi, this is based on something that was created by X person, and I'm using it now. Use of this license will simply require that you make a clear statement, we'll give you the text, that your game is based on our material. Unlike some other Creative Commons options, this is not viral. You don't have to make your derived content open to all. We think it's awesome if you do, though, because it means you're contributing something back to the community. Fine. To make use of the Descended from the Queen logo, you must include the following text. For the Queen is trademark of Alex Roberts. The Descended from the Queen logo is copyrighted Alex Roberts and is used with permission. Yes, if I wanted to put this particular image on my game, which I have not, because it just doesn't meet the aesthetics of the logo, I just chose not to. I would have to give the attribution of who owns the trademark For the Queen and Descended from the Queen logo. So For the Queen is trademarked by Alex Roberts. The Descended from the Queen, you notice, isn't trademarked and is just copyrighted. Fine. Both of these statements so far are true. This is all very true. A guide to using the For the Queen SRD with Creative Commons, okay, whatever, copying. The first right you have under the Creative Commons Attribution License is straight up copy of the SRD. If you do this, just remember to include the original copyright notice found in the documents and don't add any kind of copyright protection. Yes, if I am copying directly from your work, I need to give copyright attribution. And yes, this is true. You have the right to create new works that are derived from the SRD. Here is where we're going to have issues, because this statement might be useful for you to know that the Creative Commons Attribution Unported license was written for using the terminology of the Berne Convention and various WIPO copyright treaties. Yes, great. This is true. This Creative Commons attribution was written that way. So you shouldn't run into any problems if you're publishing in a jurisdiction other than the United States. Also true. But it still doesn't involve what you actually said. Now, of course I have the right to create new comments derived from the SRD. This is where things get interesting. The biggest requirement for anything you do based on our work is attribution. You must give us credit for our work. Okay. Hi. You cannot copyright mechanics. So legitimately, the only thing of a For the Queen game that I would actually have to give attribution for on a game that I write is the fact if I copy word for word any of the cards created by Alex Roberts or Evil Hat Productions. Or if I chose to use the term descended from the Queen on any of my games. But the straight mechanics of a prompt card using a question that I then change the wording on and write my own question tied to whatever I'm writing, that is not subject to your copyright. That's a mechanic. The expression of a mechanic can be copyrighted. So if I chose to use your rule set copy and pasted, which I have done on 2 of the games I have written because it made it easier, then yes, that I would have to label as being part of the SRD. But the actual content of my game, the mechanics, the way the game functions, that is not copyrightable and that is not protected under this SRD, no matter what they say. So if I wrote a Descended from the Queen game, where I did not copy and paste the rules as were written on the card from Evil Hat and Alex Roberts, I would not have to give any attribution. Ever. Because it's a mechanics set. And the mechanics are not copyright protected. It is only the expression of the mechanics that can be copyright protected. It is why Dungeons and Dragons, all of this, if we go and open D&D Beyond, right? And I just randomly go into, let's say, you know, a rogue, right? All of this flavor text, all of this right here, this is necessary. This phrasing of how the skills work, this table, may or may not be subject to copyright protection because I'm going to come back to that. This phrasing right here may or may not be subject to copyright protection. We'll come back to that. But this expression, sneak attack, thieves' cant, cunning action, all of this is all going to be subject to copyright protection because it is the expression of the mechanic and not the mechanic itself. But the For the Queen SRD is literally, you can't use the SRD to make something which would be prejudicial to Evil Hat Productions or Alex Roberts' honor or reputation. That's how the legal license puts it. We're not sure how you do that, but don't. Basically, it would be something defamatory, and if I was writing a game where I would say that Evil Hat are the villains of it, that could be considered defamatory, and that would be protected. So here's the thing. This statement right here, so these are the requirements of the SRD, right? Like, these are the requirements of the SRD. Okay, you have to give them credit for their work. Attribution is fine. You can't imply or state that Alex Roberts or Evil Hat Productions is endorsing or sponsoring you unless we've made a special arrangement with you. Okay, I can't turn around and say sponsored by Alex Roberts, or put any of the, logos or indications of Evil Hat on there. Fine, I don't use the Evil Hat logo or the For the Queen logo without talking to us first. Again, makes sense. There is the Descended from the Queen logo that you can use, and you have to give, also don't use the name For the Queen in the title of your product. Again, all of this is fair. That is all copyrighted terms and images, and even a trademarked term. Third, you may not use any material from the For the Queen that is not in the SRD content, including but not limited to specific prompts and artwork. You must create your own original material using For the Queen's system as a base. If I can't use any of the prompts, then all I am using is the mechanics, right? And if all I am using is your mechanics, then this is not actually an SRD and it's not actually a license. It is a license to use your particular created logo and an attribution that you created and published a game, not that what the game that I wrote is in any way a licensed product, because you cannot copyright mechanics, you can't then license the mechanics, right? If you don't own the thing, you can't try and sell the thing to somebody else. We have a con, that's a traditional con man thing, right? Like, I have a bridge in South Florida I want to sell you. Well, I don't own the bridge, so me trying to sell you that bridge is just a violation of the law. You can try and buy it if you want, because there's a sucker born every minute, according to our dear friend P.T. Barnum. He's also not wrong, although his timeline has changed significantly in the last 100 years. So... this isn't an SRD. Well, I mean, it is, but it isn't a license. This is not a licensed game. Now, do I still put attributions for Alex Roberts and Evil Hat on all of my games that I publish that are Descended from the Queen? Yes. Do I use their logo for Descended from the Queen? No, not really. I don't feel a need to. Do I label them as Descended from the Queen games? Yes, because it is a good marketing idea. Do I give attribution for the use of copied terms for expressions for the mechanics? Yes, because that is what you should do. Do I need to do that for any of the actual content of my game? No. Because the actual content of my game is all my own individual thoughts, words, and phrasing. Or if it is not, it would be considered a term of art, like as certain types of expressions that are idiomatic or a metaphor, and therefore also not subject to copyright or trademark. So they got a really good lawyer to write them a document that you could challenge in court and have no reason and win on. The problem is, a lot of people do this. They go and get a lawyer, and the lawyer will create this document and say that it is X thing. It's not. But most people don't know that they can challenge it because the lawyer wrote the document. And that's all the legal stuff. As always, if you're unsure about what exactly to do, or if you're investing a lot of money in publishing something based on our work, think about talking to a lawyer. Yes, all of this. But again, what's based on your work, the only thing that would be a problem is if I used your trademark, your license, which, by the way, according to your rules, you don't want, the For the Queen is a trademark. So, you know, all of these things are why a lot of people struggle with copyright, and a lot of people struggle with what things say or what they don't say, or what people can defend or not defend against, what is considered fair use. All of these things are complicated issues, and although you get tired of hearing it from a lawyer, the "it depends" really is the true statement. It's like, you need the law is subject to the facts in question. Like, the issues might be easy, but what law does or does not apply, or can or cannot be used, or is all subject to the facts in question. So, what are... No worries, Jim. Have a good one. We are going to go ahead and we should take a short break now, because we've been going for 2 hours and I need to stretch and get some more water and hopefully, you know, grab a snack. But we'll come back, we'll go over what the SRD and the OGL for Dungeons & Dragons are, and we'll talk about what that actually means for people, and people who are writing. So take your moment, refresh, stretch, bio, do all of those good things, and thank you everyone who came in from that raid from Gnome and the crew. Thank you, Gnome, thank you, Eris, it was great to have you guys come join us. But we'll be back in a few minutes. And I will probably run the ad during the break to try and limit the pre-roll ads for people as they come in. All right. See you in a few, everybody. Hi. Apparently I accidentally muted the mic. Thanks, Trig. So, sorry that took a little bit longer than expected. I was, right as I was about to come back, our order from Misfits came, and I wanted to make sure I put all of the cold stuff away in the freezer in the fridge before I came back and it got left there or whatever. How are we doing? We having fun? We feeling okay? The life getting to us all? Happy holidays, welcome in, Flounder. Yeah, the game is a little fun. I learned about that from Jess, Fawn and Games. They're a wonderful streamer. Actually, let me see if I can shout out. Work. That doesn't work because I can't spell. Well. I should be able to do this a lot faster. Oh, okay. So let's try this again. There we go. Fawn, who's a wonderful, wonderful streamer. They do lots of cozy, comfy, wonderful games, and they are wonderful, wonderful peoples. Okay. So, back to answering questions. All the fun things. Yes, I saw your question, Ice Benny. Why is the bar called a bar? If I think of a bar, I think of a fancy... Yeah. So, that's a term taken from common law and tradition because it came from England, and where for a very long period of time in England, there wasn't a tradition of having lawyers represent you in public matters. You could have lawyers that were called, which is why they still have the separation between solicitor and barrister. And a barrister argues in a court, and a solicitor does all of what we call transactional law in outside of the actual courthouse. Contracts, wills, all of this kind of stuff. Anything else you would talk to a lawyer about that's not actually being in court, you would talk to a solicitor. If it was actually in court, you would hire a barrister. And the bar is literally the bar that you could approach to talk about and present your case. So a barrister is one who could approach the bar in the courtroom to present the case. And now it's used as a term of art to refer to any, basically the guild of lawyers that exists. It's a thing. But we are talking about the SRD and how the SRD and the OGL work for the purposes of Wizards of the Coast, which is a very different thing than a lot of places. So, and again, we were talking just before we left about how this For the Queen is a thing. Yes, Unstable Dios. I'll probably put it up on YouTube. The only things I don't put up on YouTube are usually my video game streams, just because I don't think enough interesting things happen there. But all of my academic nerdy talks are on the YouTube. All of the, all the TTRPG stuff is on YouTube. All of that fun stuff is on YouTube. So yes, this will probably go up on YouTube. And if you have to bow out because you gotta go do real life things, I understand. Perhaps the collective term for lawyers should be guilt instead of guild. I mean, don't you mean guilt, not guilt? G-I-L-T, not G-U-I-L-T? Hey, Time, welcome in, by the way. So yes, so we were talking about this SRD from For the Queen, which is basically claiming rights that it doesn't have. Okay, Flounder is correct. We are a gilded guild with no guilt. That's fair. Oh, always, feel free. The VOD will be up for about a week on Twitch, but it'll go up probably tomorrow-ish, depending on the rest of my schedule on YouTube. But we were talking about the SRD and the actual SRD from Wizards of the Coast. This is the systems. This is on their D&D Beyond, on dnd.wizards.com. This is their reference, their systems reference document. You can find it on their website. Very easy. You can just find it Googling as well, but it's a little more complicated because what pops up first because of Google is, you know, a bunch of people complaining about the SRD rather than the actual document itself. Because why would you want the actual document itself? So the OGL and the Dungeons Masters Guild offer different kinds of publishing opportunities. Below is an overview of the diet programs. So we will look at the actual document. And this was last updated May 4th, 2016. It is the most accurate and updated version. Therefore, this is the version that will be into effect until the new version goes into effect. So we're gonna look at this. Oh, back for a second. Okay. So you want to design content using the 5th edition rules for D&D, the OGL, and the DM's Guild. I want to publish my original campaign world using 5th edition rules. You need to use the OGL, which means you need to cite to the OGL, which means you need to give attribution. The DM's Guild does not allow that. I want to publish content using the Forgotten Realms. You need to use the DM's Guild because the DM's Guild is the only one that has the license to that particular world. The Forgotten Realms. Forgotten Realms. Ravnica. Eberron. Ravenloft. The Dread Plains in general. Greyhawk. All of the campaign settings are not covered or available under the OGL. You want to publish anything that are in those worlds, that are the published campaign settings of Wizards of the Coast and D&D, you need to publish the DM's Guild. I want to print and sell my 5th edition D&D product on my own. You're doing it independently and you're not going through going through an additional publisher. If you need the OGL. I want to sell my product in the D&D online marketplace. You need to go to the DM's Guild. I want to sell content rated by the largest network in the D&D player. Okay, this is just shilling. These two are just shilling for the DM's Guild, right? We know the DM's Guild is owned by WotC. We know that it is the biggest and easiest means to publish upon. We know that there's terms and conditions in the TOS for DM's Guild that basically say, hey, you're allowed to publish on this platform, but if we, WotC, decide that we like your D&D content, we can take it for a fee and then make it ours. I want my content considered for additional publication by WotC. Oh, look. This is the phrase we were just talking about. I want my content considered for inclusion in digital games. I want my content considered for inclusion in Wizards marketing. All of that requires to be on the DM's Guild. Okay, so we are going to look specifically at the OGL. Who goes to the source documents and materials to complain when you can complain about people reacting to the reactions of this endorsement daily? I mean, in this channel, we have a command for that. I always go back and check the source material over the translation. Alright, so this is where we get to have a lot of fun, and I'm going to sound like a person. Alright, this is 403 pages. We are not reading all 403 pages. Bringing back, they can eminent domain your DM Guild content. Yeah, exactly. But admittedly, they'll pay you a relatively fair price for it, at least for according from people I've heard. But at the same time, they don't have to. They usually do, but they don't have to. So this is 403 pages. If you want to publish D&D material, either as an independent contractor or as a business or as an LLC or just anybody who wants to publish on the DM's Guild, you should read this document. All of it. It will be confusing. It will be in doublespeak. It will reference terms, and then you'll have to go back 5 or 10 pages because it'll be like, oh wait, what is the definition of this term in this instance? There, it's at the beginning of the thing. But it is important if you ever wish to publish using a document for an open gaming license, an SRD, to actually look at what the document is. For example, this whole legal document isn't on this anywhere, right? We go to click the SRD. This is the SRD. But it actually... So, let's talk about this. The only portion of the SRD that is actually required on For the Queen, that is actually published, is this paragraph. There's no legal explanation in here. And Ice Bunny, to answer your question, did Critical Role do that to publish their stuff? The first thing that Critical Role ever published was, Matt Mercer published the Blood Hunter subclass by himself on the DM's Guild. And then after that, they were big enough that they were doing independent work. So the next book, the first Exandria book was published as a WotC product, and then the next D&D book is published separately under their own publishing agreement, which means they probably have an independent license with WotC. I guarantee you they have an independent license with WotC. Oh yeah, so either a profitable or a peppercorn price. Yeah, exactly. So this is the SRD for the Queen. Remember how we said that mechanics cannot be copyrighted? Mechanics can't be copyrighted, recipes can't be copyrighted, the expression of the mechanic can be copyrighted, and the expression of a recipe can be copyrighted, but the actual mechanics themselves cannot be. So... you have the issue that in For the Queen, the actual, all of the prompt, the function of using a prompt card till you get to a final question, all of that is mechanics. And because according to their SRD, they say you can't then copyright their prompts, or copy their prompts, everything after the initial rule set isn't subject to the SRD and is your own copyrightable material. And really, you could get away with publishing this whole thing if you reorder the, you know, definitions and use your own definitions of the instructions. Because without giving attribution to For the Queen in any way, shape, or form, because everything else is mechanics. I didn't think so, Jer, although I could be wrong. Jer's might be right. Well, now I want to know. This is why I check the data. Did Green Ronin publish a Critical Role campaign? Okay, Tal'Dorei campaign setting. Okay, so the Tal'Dorei campaign setting, you are correct, was published. So Tal'Dorei was published by Green Ronin, and then the next book, and it's out of print probably because of the way Green Ronin works. And then Exandria is a Explorer's Guide to Wildmount, is a WotC book. You are correct. Jer is correct. I was wrong. I am okay with being wrong. This is why we check the data. We check sources here. But yeah, so like the first... and then all of them go through the DM's Guild. So yeah, so... go right ahead, Ice Bunny, you can ask all the questions you want. Since all the characters, you can't use the Queen, because all of those art is under license to For the Queen, so you can't use those art. You have to use, this? Here's the way. And I could even make an argument... I could even make an argument that this whole paragraph right here, well... this whole paragraph right here, when a player draws a question card, they have three options. Read it aloud and answer it from their character's point of viewpoint. Pass it to the next player in turn, saying, I'd like to hear your answer for this question. And tap the X card, or otherwise indicate the card's being discarded and draw another one to replace it. I could make an argument that this becomes a term of art and therefore isn't subject to copyright either. Because while, again, the expression of an idea, like, mechanics are not copyrightable, the expression of a mechanic is copyrightable, a term of art or when there is such a thing as no other real way to express something, that also can't be copyrightable, right? Like, if I'm giving you directions to my house from a particular location, and I come to say, you come to the corner of X and Y, and you make a right-hand turn, that statement can't be copyrighted because you come to the corner of X and Y is a real true statement. It will happen. And making a right-hand turn is the only way to tell somebody the actual directions from my house from a particular point. So so it becomes a term of art and therefore... Oh yes, thank you, Unstable Dios, thank you. So a term of art doesn't actually have to do with art and the pretty stuff. A term of art has to do with the way in which various groups, and I'm using the term group because it can be professions, industries, businesses, various other things like that all have their own lexicon, use things like a term of art, right? Like, all groups form their own lexicon and words, quote unquote, their own slang. You know, if you're in a corporate office, right, and like you work for this particular company, and this company consistently uses, for example, a KPI, right? Like, the term key performance indicator is a term of art when it comes to business, because it is a concept that has become so universal that it is not protected by copyright anymore. All of them have it. Now, each company's definition of what their individual key performance indicators are is going to be different, but a KPI is, the term KPI is just going to be a KPI. You have a term of art where it's specific words and phrases that are used consistently by the in-group. Yeah, more the term than the art. Exactly, Jer. More about the term than the art. In this case, it's the in-group consistently uses this one. For example, those of us who stream, we don't say VODs. We say VODs. We all say VODs. We just do it. It's just our term of art. But I was talking with my sister, who actually works in marketing, and she works in ad placement. And so if you have a big company that wants to put ads on television or on Twitch or whatever, she's the person that will work with the platforms to arrange where the ads are going to go. She also works with the ad creators to make them all look the same and arranges them so they end up in the right place. On her side, she's saying, oh no, we always use the term VOD. It's always the VOD, on the VOD, for the VODs, whatever. I'm like, yeah, but the people who are actually doing it call it VODs. So that is what is called a term of art, when the in-group has a new understanding and of definition. So it can also be called a scene of fare. Those are more usually used with theater, film. So a scene of fare is like a trope. It's not totally a trope, but it is similar to in concept to a trope. It is a concept that is so universal in film or theater or story or any form of expression that it really is not subject to copyright anymore. Like the general idea just inherently isn't, because it's a scene of fare, and it becomes so universal that multiple people can use it. But then it use that same scene, that same trope, and do it in different ways, right? You can't copyright having a big family, the concept of having the scene of a big family dinner in your movie where there will be a dramatic reveal that the father is not the father. And there'll be a big, huge fight over a holiday meal. Hey, Ice Bunny, what happened? But StarCraft lovers are so my copywritten concept. No, it is not. Hey, you want to know who's going to lose that lawsuit? The whole concept of, I can't even believe I'm going to have to use this example. The Omegaverse lawsuit. She lost that because it is not, it's a scene affair. It's a trope. You can't copyright that. Oh, you threw a snowball in emotes? Oh, no, I figured Nightbot is being messy because it thinks you put too many emotes, which, what did I put in the... Oh, what? No, Nightbot is being really weird. It's saying excessive emotes are 3. No, I did not put that. I put 15. There we go. Let's fix that. Thank you, Ice Bunny, for helping me. Exactly. So a scene affair, a term of art, all of these are things that are going to tie back to the concept of your expression of your idea can be copyrighted. But sometimes the general idea itself can't be. You know? These are all things that are important to know. But, so yeah, so the SRD is literally this whole section, which is literally just the rules of the expression of the rules of the mechanics. That is what is the SRD. Or this idea, which is an expression of the mechanics. Okay, if I put this in my game, I would have to give attribution because it would be copy and pasting their expression of their mechanics. But the actual, you know, phrasing isn't necessarily. This is, again, their SRD. 90% of this SRD is not actually copyrightable. And wouldn't actually benefit from copyright protection. And if anyone actually chose to, not me, because I'm not that person and I don't wish to, but I want to point out that if they had someone who wanted to challenge the copyright protections of this SRD, be really easy because the only thing that they would actually be copyrightable is the individual prompts. That would be it, because everything else is mechanics. Versus this is the OGL, all 403 pages of it. The SRD and the OGL for Wizards of the Coast. All 403 pages of it. See how big? This is what? Max 5? And that's assuming that you've got big font. Probably closer to 3 pages. Total. So, let's point out a couple key points on this, alright? So, like, is game mechanics treated in a similar way as business practices? No. Business practices are inherently separate from game mechanics. Business practices are not copyrightable in and of themselves because there's nothing to protect there, right? It's the practice. It might be eligible for trade secret, which is a different thing altogether. And trade secret is, for example, the recipe to Coca-Cola is subject to trade secret protection. They have actively, for the past 100 years plus, made actual strong attempts to keep the active recipe of Coca-Cola a secret from the industry. They have not shared it publicly anywhere, officially and legally. I've met one of them. There are 3 people who all have individual keys to individual safes in the main headquarters in Atlanta, and each of them only have a third of the whole recipe. Again, they protect the information, they limit who has access to it, they limit who knows where the information may be stored, and they limit where the how the information is expressed. That is all considered trade secret. So even if somebody went and bought a bottle of Coca-Cola off the street and pulled it in and is like, I'm going to, yeah, it's really intense, pull it into like a mass spectrometer, like you see in TV on the, on all of the crime shows, right? Like the mass spectrometer is going to tell me all of the chemical composition of this thing down to its smallest particulates. You theoretically could go pull that bottle of Coca-Cola, pull it off of the shelf, pull the, attempt to recreate the recipe from individual sale, and Coke can sue you for if you attempted to then sell the formula, because it would be an infringement and a violation, because they have attempted and worked very hard to maintain their trade secret. Additionally, it won't actually help you all that much, because a large part of the trade secret is also process, and while anybody who cooks will tell you that half of a recipe is ingredients, but the other half is process. And if you don't know the process, you might have all the ingredients and still come up with everything. Isn't the big trade secret just cocaine? No. They had to remove that. It's no longer so. Yeah, Ice Bunny. So exactly, like you can have things like RC Cola or Pepsi or various store-bought colas that are attempting to replicate Coke, but it is not. Barley tea does not equal beer. Those two things. It is not the same thing, and so, but because they are attempting to protect their trade secret, yeah, exactly. That's the other thing, is like, so that's the process, right? So the ingredients you might have, but you don't know about the process. You don't know about the timing, the temperature. You don't know about the order of the ingredients, right? Not just when to add them, but what order they go in. And then all of those things are protected. And then because you don't know them, any attempt to recreate them could lead to lawsuits. Now, the Pepsi-Coke dynamic, and we all agree that Coke is inherently better, is going to cause a different thing. There were attempts earlier on to deal with it, and it kind of caused other things. So, looking at this document, I'm just going to pull some basic points about this document. 100% Coke is better than Pepsi. Yep. Pepsi might be 20 minutes west of me in the grand scheme of things. But nah, man. It smells fake. You can keep it, Hawkeye. We won't stop you from having it. It's just we acknowledge which one's better. So I want to pull out a couple key points in this document. And then make sure that you're aware of them. And again, if you are going to create anything under the OGL, under the new, excuse me, depends on which one I have in the time at the end of the day, honestly. Nah, see, I will always choose Coke over Pepsi, and sometimes if the option is just Pepsi, I will just choose something else that is not. I am one of those people. It's okay, Hawkeye, we still appreciate you. So again, anybody who wants to write in these things wants to make sure that you, oh, also, I should do the thing. Hi, again, everyone. I'm your friendly neighborhood Prax. I should remind people of this on occasion. I came back and I didn't do that because we got so busy talking. I use she, her pronouns. And if you came in on that raid with Gnome, I would really appreciate it if you could just click the little circle icon underneath, because then it'll register you as a real person and not just a raider. And if you like, we're glad you're coming and hanging out. But again, this is an OGL, this is a thing. You want to take the time to read the whole thing. We are not going to read all 403 pages on this stream. I got life, you got life. It's a thing. So, also, Hawkeye, since we're talking about trademarks and licensing, I should point out that every time you put the TM after diet water, make sure you put something else in there too, because otherwise somebody could actually theoretically sue you for claiming a trademark that you don't own. Well, that's not true, because you are using it in commerce. So you can make an argument for using it in commerce, and therefore even if you haven't registered it yet, because you're not using an R in a circle, therefore it's not a registered problem. If you were using an R in the circle, it would be a huge freaking mess. But the TM is okay. Because you're using it in commerce. And common law guarantees you that right. Alright, so. Now, we want to pull out a couple things here that are important to know about if you are writing something and you want it published in a way that you will make money off of the product of Dungeons and Dragons. So, this this huge paragraph right here, we're gonna focus in on this for right now. And I'm gonna blow it up a little bit bigger, make it easier for everybody to read, right? Like, that's easier for everyone to read. The following terms are designated product identity as defined in Section 1E of the Open Gaming License, version 1.0a, and are subject to the conditions set forth in Section 7 of the OGL and are not open content Dungeons & Dragons, D&D, Player's Handbook, Dungeon Master, Monster Manual, D20 System, Wizards of the Coast, D20 when used as a trademark, Forgotten Realms, Faerun, proper names, including those used in the names of spells or items, places, Underdark, Red Wizard of Thay, the City of Union, Heroic Domains of Isgard, Ever-Changing Chaos of Limbo, Windswept Depths of Pandemonium, Infinite Layers of the Abyss, Tartarian Depths of the Carcieri, Grey Wastes of Hades, Bleak Eternity of Gehenna, Nine Hells of Baator, Infernal Battlefield of Acheron, Clockwork Nirvana of Machinus, Peaceable Kingdoms of Arcadia, Seven Mounting Heavens of Celestial, Twin Paradises of Biotopia, Blessed Fields of Elysium, Wilderness of the Beastlands, Olympian Glades of Arabia, Arabia, Concordant Domain of the Outlands, Sigil, Lady of Pain, Book of the Exalted Deeds, Book of Vile Darkness, Beholder, Gauth, Carrion Crawler, Inari, Badatsu, Displacer Beast, Githyanki, Zerai, Mind Flayer, Illithid, Umber Hulk, and Yuanti. Yeah, all of this is not part of the SRD and OGL. So, fun fact, Commander Pulsar, these are all realms and locations that, due to the now merging of Forgotten Realms and Baldur's Gate into Magic the Gathering, you could get these lands as Magic the Gathering cards now, because they're all owned, they're one of the things. Exactly. Let's all hope that the lawyer writing this was a nerd and understood exactly what they were writing about. Which is true, and a good thing. So, you'll notice things like, there are terms in here such as things like Abyss, Hades, Gehenna, Acheron, Arcadia, Celestia, Elysium. All of those require the precursor phrase for it to be subject to copyright, because otherwise they're just they're common locations. Yeah, this document was written by several people. several lawyers probably were involved in this. At least some of them were, you know, low-level associates who had to do the general beginning writing, and then a partner took over and was like, yeah, we're going to change it like this. All of the rest of the SRD 5 is open game content as described in section 1D of the license. The terms of the Open Gaming License version 10A are as follows. They define contributors, what it means to derivative material, what it means open game content. This is important here, guys. And what it means to distribute. So distribute means to reproduce, license, rent, sell, broadcast, public display, transmit, or otherwise distribute. Broadcast is important here. So any one of us that has created a homebrew world and then streamed your game in your homebrew world using D&D rule set is using the OGL. You put it up online using the OGL. It's also, at this moment, subject to the fan content policy, which is a separate beast and is staying way over there for right now. Open game content means the game mechanic and includes the methods, procedures, processes, and routines to the extent that such content does not embody the product identity and is an enhancement over the prior art, and any additional content clearly identified as open game content by the contributor, and means any work covered by this license, including translations and derivative works under copyright law, this specifically excludes the product identity. I know it's all for game purposes, but there feels something intrinsically disgusting about copyrighted realms of the afterlife. Yeah! I mean, that's why they have to put the heroic domains of Isgard, Asgard, and the ever-changing chaos of Limbo. Right? Like, you can't just copyright the word Limbo. You have to call it the ever-changing chaos of Limbo. Which is very weird to me. Conceptually speaking, as a definition of Limbo. They give a definition for use, which is also important here, right? They're giving a definition for what it means to use. Use, used, or using means to use, distribute, copy, edit, format, modify, translate, and otherwise create derivative material of open game content. Yeah, exactly, Jer. Limbo, okay, look, side note. Limbo is theologically antithetical to chaos. It's literally, admittedly, I also, you know, Limbo is closed as well, right? Like, no, Malkadoshian, the Catholic Church has not abandoned Limbo. Nobody has abandoned Limbo. Limbo is closed, according to Catholic doctrine. Hi, I was raised Catholic. I did teach at a Catholic high school. I went to a Catholic high school. I know a lot about this. I did this. So Limbo is, according to Catholic doctrine, Limbo is closed. Limbo of the Fathers, because that is the important full name of the whole thing. Limbo was the resting place of all of those good people who died before the birth and the resurrection of Christ, because they couldn't go to heaven because of original sin. So, according to Catholic doctrine, after the crucifixion and Christ dies and he's buried in the tomb, he descends into hell and he descends into limbo, not actually into hell. He descends into limbo, he collects everybody who is in limbo and brings them with him up to heaven and closes the gates of limbo behind him. Purgatory still exists. Yeah, Gehenna is also Gehenna is Christ used for hell, maybe. Gehenna is also a rabbinical idea, much more than a like hell as a Christian connotation of it. But either way, Limbo is A, closed, and B, was just like a really chill waiting room. And now you go to purgatory. So, you know. Exactly. Limbo is a plane of existence that is literally locked and closed, metaphysically speaking. Yeah, the race condition that the sequence wasn't of emptying Limbo. Yes. Yeah, and again, Gehenna's a very exclusive club. It's weird. No worries, Malk. For those of you who don't know, in addition to being a third-year law student and I study IP law, I am also a legal intern, which means I can sign legal documents and actively practice law with supervision in the state of Connecticut. Very important distinction there, I want to be clear. But I also, my undergraduate degree is in classical languages and literatures, and I have made a long history in anthropology and linguistics. So I've studied a lot of theology, various theologies, and I have a lot of experience, particularly with Catholic doctrine, Christian, a large number of other Christian doctrines, a lot about the various Jewish traditions, but again, from a more linguistic, anthropological, and archaeological standpoint, although modern rabbinical law I'm not as up on. I have a general understanding of, but you want to talk actual theology about rabbinical understanding of things, I'm going to defer to specialists in that one. But again, if we're talking about anthropological understandings of religion and various major religions worldwide and historical expression of those religions, yeah, I have a lot of understanding of almost all of the major players. I'm not as up on my Hindu religions, mostly because I haven't read enough. I don't have enough of the first primary source understanding to be comfortable in them as I wish. But general understanding, but again, I would still defer to subject matter experts in that one. But yes, going back to this. So, this is a very specific... The license of the OGL is both at times very specific and very open. It has to be, because it has to be very specifically... Exactly, Flounder. Very lawyerly, Prax. I will need to do more research and/or consult others to whom I will defer. The fancier of it depends. Oh, you missed it, Flounder. Wait, where's the clip? Somebody's got to have the clip handy, right? Because I gotta gif that. That's gonna be a gif we're gonna make, everybody. It's the it depends. the biggest lawyer answer. It depends. But the OGL has to be both combination of both very specific and slightly generic. It has to be very specific to be a license, right? A license is a contract at its most core basis. A license is a contract. And one of the major things about a contract is that it cannot be ambiguous. If the contract is determined to be legally ambiguous, then the contract is null and void. So something like the OGL has to be clear, defined, specific in what it covers and what it doesn't, and what its definitions are, so that it can meet the qualifications of being unambiguous, while at the same time being relatively open, so someone who is a non-lawyer, who is creating content in and of for themselves, can read this and have the opportunity to understand what's being said, and have the opportunity to use the license. So again, we've got this definition of use. Use, used, or using means to use, distribute, copy, edit, format, modify, translate, and otherwise create derivative material of the OG content. You or your means the licensee in the terms of this agreement. Licensee here means specifically anyone who's creating something and is using WotC's property to do it. I don't understand that statement. I might be missing something. I've been there before. So the license applies to any open game content that contains a notice indicating that open game content may only be used under and in terms of this license. You must affix such a notice to any open game content that you use. So if you are publishing, remember we were talking about like the Uncaged anthology, or anyone who's the Wild, Tales, Explorer's Guide to Wildmount, all of those things, well, not the Wildmount, the Tal'Dorei book. Wow, I just messed that up. The Tal'Dorei book, anything published by a third-party person has to state that they are using content from the Open Gaming license as part of the license itself. And here we get to the most important statement. Oh, okay. It's okay, Ice Bunny. I'm sometimes it's just I just misread things. So here is the most important statement. This is literally, I'm gonna make it even bigger so you can read this. This is the most important statement in this entire text. Offer an acceptance. By using the open game content, you indicate your acceptance of the terms of this license. By choosing to use their content, you agree to their terms in the rest of this contract. They don't have to sign anything. You don't have the opportunity to counter offer, at least under this license. You don't have the opportunity to make any disagreements or change any verbiage in here. By picking up and writing and using the open game content, anything that is available under the SRD for Wizards of the Coast, if you use that, you are saying, I agree and accept these terms, and I will be willing to be bound by them, which I guarantee are also going to include some very interesting things. And according to courts in the United States and in other jurisdictions worldwide, Europe, Japan, China, this counts as a valid contract. You don't have to change this. Exactly, Flounder is correct. What a clear and unambiguous action to accept the boilerplate text. When we use the term, when lawyers say that the text is boilerplate, right? That is a term of art basically to mean that you got set a form letter, a form, license, which is effectively what this is. If they were sending one out in the mail and you accepted it, whatever. But the act of using but the mere act of using it means that you've accepted this license. Good on you. Now you don't get to change anything. Now, here's the next important thing. In consideration for agreeing to use this license, the contributors grant you a perpetual, worldwide, royalty-free, non-exclusive license with the exact terms of this license to use the open game content. If you accept our license, we will allow you in a perpetual, worldwide, royalty-free, non-exclusive license with the exact terms of the license to use the open game content. This paragraph is where people are going to get upset. Because if we go to this new announcement, right? If we go to this announcement, for fewer than 20 creators worldwide who make more than $750,000 in income a year, we will add a royalty starting in 2024. So even for the creators making significant money selling D&D supplements and games, no royalties will be due for 2023, and all revenue will below $750,000 for future years will be royalty-free. This statement means that this BS wrong belief that Paizo will simply use the old OGL and not have to pay the royalty is idiotic. It's right here. This statement is going to go away. It's going to get changed. It has to accept the new concepts that they're going to use. But there are certain things which you cannot be held to even if you accept the contract. Not that it's applicable, but it can appear with regards to employment. An example of which is non-compete agreements. No, actually, Unstable Dios, in the United States, non-compete agreements are valid. The specific terms of a non-compete agreement can be considered, Faye, it's not, what are the 3 bad things for contracts? It's unambiguous, what's the moral one? Not unfavorable, but, oh god, what is it? Unconscionable. Certain terms of a non-compete agreement, thank you, Flounder, of a non-compete agreements can be considered unconscionable and therefore can void the whole agreement. But the concept of a non-compete agreement in and of itself is not unconscionable, according to the within the US and even in Europe. Most non-compete agreements have a time limit to them. And that's the biggest things that the most common thing today in modern contemporary society that would be similar to what you're thinking of Unstable Dios, where you even signing the contract, it wouldn't mean any, they can't enforce that term, is if the term is ambiguous, where they're, which is basically the general rule of thumb, except for the state of California and New York, is if there are multiple definitions of the same word in the sentence, then the contract is inherently ambiguous, and there must be a definition provided that both parties agree to, and if there isn't, then the contract can be declared null. The other big thing about terms that may not be applicable even if you sign it is in waivers, safety waivers. In the US, it's definitely become a concept of contributory negligence is kind of gone away. Most of those waivers nowadays aren't actually for court, for lawsuit purposes, it's for insurance purposes. Like if you, for example, the very unfortunate incident that happened at TwitchCon with the woman who broke her back in the ball pit. Even if there is a waiver on file, that event took place in California, which means it's subject to the laws of California. Also, Twitch is incorporated in California, so everything that they do is subject to the laws of California, and they form select California, which means even if you live somewhere else, they're going to make you sue in California. According to the laws of California, you cannot waiver negligence and you cannot waiver safety standards. So by failing to meet the safety standards or being negligent in any way, the waiver is invalid. There's no validity to it. And California has really, really broad definitions of what it considers safety negligence. So effectively, any waiver for an athletic, a dangerous activity in the state of California is effectively null. Basically. Those waivers, however, serve the purpose of insurance, where the insurance company can say, okay, you covered this by finding the waiver, and therefore we will be willing to we will pay the indemnity that comes out of this event, this accident. Yes, so Flounder brought up another important concept. When a term within the contract is ambiguous, but it can be considered severable, and therefore won't void the whole contract, but only get rid of that. You basically cut out that particular term and pull it over here and force it to be renegotiated, but the rest of the contract, it's when the term is it's when the term of the contract is not, I want to use the not lawyery terms. It's when the term within the contract is not vital to the performance of the contract, right? Like, if in this case, this would be considered a vital term to the contract, right? Like, you are taking this agreement as part of this whole thing. But a non-vital term of the contract might be something like, say, for example, you are selling, I'm going to be that great lawyer and use a term that every lawyer and every law student in the world has ever seen, called widgets. They're very important things, widgets. So if you are a seller and you make a contract to sell your buyer 50,000 widgets, and you agreed in the contract terms that you would deliver 50,000 widgets on X date at X location, the number of widgets, the where it's going to be delivered, what the time and place of it, all of that is non-severable. What might be severable is how many pallets the widgets came in. Rather than, like, if you ordered 50,000 50,000 widgets and it came in packs of 1,000, versus if you ordered 50,000 widgets and, you were thinking that it was going to come in packets of 10,000, well, now you've got a very different amount of things that you're holding around, right? But that is generally considered a severable term within the contract. Also, all of this is subject to the UCC because it's goods and services sold in commerce. Well, goods sold in commerce, which is really the only thing that covers the UCC, although now apparently somebody wants to make it services that are also subject to the UCC. Again, the UCC being the Universal Commercial Code, it's generally been accepted by almost by all the states in the nation. There are like 4 states that have made adaptations to it. I believe they are California, Hawaii, Delaware, and I'm blanking on number 4. Don't quote me on that. I don't remember. So yes, something is severable if it is not vital to the performance of the contract. Or sometimes even if it is vital to the performance of the contract, but it doesn't actually harm anything. Delaware is always messing things up with business provisions. I mean, I think it's just actually they made things in Delaware they were not quite as strict versus in California, where they're like, well, let me change 50 things because we're California and we want to be weird. And that's not an evaluation of the state of California's people, it's an evaluation of their legal system. Because I would like to remind everybody out there on the internet that there is a concept that exists, also dealing with property, also dealing with property law, although mostly tangential because usually it involves physical property and not intellectual property, although some recent examples have made claims against it. There's a concept called the rule against perpetuity, right? You cannot you cannot be in the general understanding, the general concept of the rule against perpetuity is you can't leave something to somebody in your will that you have no ability to know that whether they exist or not. So you can't say, I leave my worldly goods to the next person who draws this sword out of the stone, because you have no idea whether or not that person exists or has been born yet. In reality, it's basically what is called the fertile octogenarian. It's the time at which the will was written, any living children plus any possible living children before the time of death, and or grandchildren. In the United States, however, the state of California there has been a court case. It is still valid in good law in the United States in a federal level that a failure by a lawyer to understand and accurately apply the rule against perpetuity is not malpractice. I want to reiterate this statement. This rule is so crazy and complex and a pain in the butt and so fact dependent that It is not malpractice for a lawyer to get it wrong. And in fact, that has now become a general statement on most, by most probate attorneys, people who write wills, that there is a general term that's kind of thrown in as like, and if any portion of this violates the rule against perpetuity, consider that portion to be null and void, and just throw it out. And that's what judges do, is they basically like, oh, well, this point violates the rule against perpetuity. All right, we'll just get rid of that, and the rest of the will is fine. Move on. Flounder says, I find it amusing that Delaware feels that business associations there are different than anywhere else. Yes! Although Texas is getting really weird now, too. Time says, widgets are also important in accountancy auditing, as are famous novels and vineyards in Burgundy and related party questions. Exactly! Exactly. Yeah, California allowed Girardi to practice for years. There are a number of people that California's just weird, legally speaking. I mean, I acknowledge my East Coast bias and have no desire to live east of the Appalachians, really, ever. I'll visit some places, but so going back to the OGL and this license. This explanation that they're reading, and we're going to go back to this point. So, two things. 6. Notice of license copyright. You must update the copyright notice portion of this license to include the exact text of the copyright notice of any open game content you are copying, modifying, or distributing, and you must add the title and the copyright date and the copyright holder's name to the copyright notice of any original open game content you distribute. Basically, if you use their content, you have to use their copy. You have to add their copyright to your copyright notice, which is the page in the very front of the book that has the little circle C and has the copyright publication date and all of those things. This leads over to this section over here, number 10. Copy of this license. You must include a copy of this license with every copy of the open game content you distribute. Every third-party book, every third-party subclass, spell, all of those things that you are creating need to have a copy of the license in the text that you're doing. That doesn't mean you need all 403 pages of this, right? This is the explanation of the whole thing, but the actual license itself is going to be about a paragraph and a half. Where is... Okay, no. So the actual license itself is these 2 pages, right? The 2 pages are the license itself. You need to add these 2 pages to any text that you wish to publish. These first 2 pages, that is the entirety of the license. It's really actually very simple. You have to include this copyright notice, because this is going to be the copyright that's going to be important to fulfill the issue number 6, right? Section 6. Everything else in this document is all about the species, races, the stats that they have, everything you are allowed to use, every spell, every class feature, every subclass, every, monster stat, alignment, description of items. All of this, all 403 pages of it, you can recreate. Literally, all of this is subject to, you can just, all of these creatures. Gold dragon, wormling. A copper dragon wormling, all of these things. So, all of this is the material that you would be working with to recreate. And it's because of that you end up with an understanding that the license itself is not the same thing as the content that you're using. The license is the agreement, right? It is what you are agreeing to and what are the limitations that WotC is putting on it. It's an almost free copy of the month. Exactly. They're like, so if you really want to know, if you're not sure and you don't want to read through the whole thing about what you can and cannot make, this is just a general character that I have created a number of years ago, but I'm not really going to change anything on. Alright. See what all of this is? If I clicked off of all of this, anything that pops up that's not part of this, that would be considered part of the OGL. Those spells, those everything. I'm gonna add Dragonlance this character. Ooh, not this character. Alright, give me a sec, I'm gonna be right back. Somebody's knocking at the door. Muted. Hello about that. Sorry about that. I needed to go answer a couple questions. Apparently I missed a text that was vitally important. And I fixed it, right? I think I fixed it. I'm getting volume. All good. Thank you. Okay. So like we were saying, you get a lot of different answers and or issues based on the content that you use, right? This document, this is a license, right? This is a licensing agreement. This isn't. This is somebody else's attempt to share the general SRD, but it isn't actually the license itself. And in fact, I cannot seem to find anywhere in For the Queen on their website about where the actual terms of the license are. Oh, you see that? There we go. Thank you. I'm still figuring out this Stream Deck. I'm really, really happy that so the Witcher crew brought me a Stream Deck. I'm really, really happy about it. I'm still figuring out the new toys and figuring out and learning where my buttons are. But it is working a lot better because I am liking it. I am liking that I can go from here and be all pig and in your face to here really, really quickly and not having issues. So these 2 pages of 2 columns of texts with detailed explanations of what the definitions are, what is covered, what is not, what is the offer and the acceptance. That is a license. This is the SRD and what you can use, but it doesn't actually conclude the license. And I have yet to find an actual license for this published anywhere. Now, while it is accepted in the United States that you can make a binding contract by clicking a little square on terms and conditions or opening an envelope, you cannot do that unless you actually have the ability to know what the terms are. Okay, so when they say a license is perpetual, so Trig asked this question, I am confused by the part where the license is perpetual, but will also be replaced by a new version. So that is true. When they say perpetual, it means that what you have created under this license is perpetually protected. It also means the license itself is an ongoing and not time limited. The new license, which will incorporate the majority of the old license, but will probably be changed significantly because, again, this point where it says royalty free is definitely going away for most people, or for those people over $750,000. So this is going to include that, and the license will go on and will not have a termination date. When somebody says that a license is perpetual, that means it doesn't have a termination date. That doesn't mean that the license, i.e. the contract, can't be changed or renegotiated. The new, ideally, if you were actually a corporation with actual, like if you're Paizo, right? Paizo has probably their own licensing agreement with WotC. I can't see any reason why they would use the OGL. They might have started as the OGL, but once they got to a certain point, they were operating under their own licensing agreements and their own separate thing. If they even still are using any licensed content. Roll20, for example, has its own licensing agreement. Exactly. Flounder says, as a metaphor, consider vampires. They are perpetual. They can be ended, but will not just end without other intervention. Exactly. They just exist, right? Like, the license is ongoing, but it doesn't mean it can't be changed or terminated. It just means it doesn't have an end date. And this is important because most licenses in comparing perpetual contracts to vampires isn't the nope. I love it. But vampires are important. But we'll come back to why vampires are important, at least for my channel, in a little bit. Best PR. Yeah, but I mean, you're making contracts with bloodsuckers anyways. So this is what a license looks like. Let's see. I think Free League, I believe Free League Free League Publishing, I believe they also have a licensing Oh. League publishing SRD. So here's an example of where they're being very specific. Here is the current OGL for Year Zero engine, which is the rules for Mutant Year Zero, Coriolis, Tales from the Loop, and Forbidden Lands. But again, that's a mechanics system. So let's look at what they're actually claiming. Yeah, occasionally. All right. Yeah, give me the text. The text of the license. All right. Okay, so they're taking literally the text. Okay, so they're using the license for Wizards of the Coast. They recreated the... This is the light. Okay, so does that mean that everything in the Year Zero system is... Okay, I'm confused. I haven't actually... I'm gonna laugh if this whole document is invalid. Welcome to the Year Zero. This document contains the core Year Zero engine for tabletop. Features. Okay, so like you could copy and paste this. Tools for the game. Role-playing game. What is characters? Okay, so this is literally just a means of... Yeah, they need to have a lawyer look at this. No. Unstable Dios, you are the WotC is not required to have previous versions of the OGL available for downloading or viewing. And in fact, they should not. The previous version, because each updated and edited version becomes the new agreement of the contract, an existence of a previous contract would in its own self become ambiguous and be a point of arguing. Yeah, like, did they just... Okay, so these are all... This is all the mechanics that are... Again, we've talked about this. Mechanics are copyrightable. Or not excuse me. Let me back up. I just misspoke. Mechanics are not copyrightable. Expression of those mechanics are copyrightable. So, if I copy and pasted this whole thing, buddy, when you have noted your relationship to the other PC, you must choose which one of them you feel closest to. That PC is your buddy. Mark your choice in the checkbox. Okay. So, like, this might actually... Some of this may or may not be copyrightable as expression of mechanics. Some of it might fall under term of art, or the only means by which you can express this idea of this mechanic. Okay, so this is all the SRD. This is all their core rules for running the game. I'm not seeing their license. I'm seeing their mechanics system and things you can use. Okay. Seeing all their mechanics, seeing things you can reproduce in your book that's just copy and paste for X reason. Okay. Most of this is mechanics. All of this is expression of the mechanics. And then their license is the OGL. Wow. 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 I don't know if any of this is valid. This isn't... I don't think this is valid. Because you haven't identified the product identity. And you've left... Okay, so look. So if we look at this page right here, right? Why can't I zoom? Let me zoom. What is the zoom? How may I zoom in this game? I'd forgotten. I've forgotten many things. Zoom. Let's zoom in on this one, right? If I look at this, this starts with the definitions versus up here, it gives you all beef. So basically they took everything away from the top that delineates what it covers. You can't... So this is basically as if you, like, they... Yeah, I mean, like, boilerplates are a thing that exists, right? In insurance law, it's very, very common, and in fact, there are groups that create what are known as the general insurance insurance law is just really big contract law. There's the group the IC the ICS that writes the claim, the general boilerplate language that the insurance company is going to use for various standard, like, homeowners insurance or corporate, or corporate park insurance or anything like that. But here's the thing, you're reusing... Okay, so you've acknowledged that what you've copied and pasted isn't... It is... The problem is that you haven't made any changes to identify this as you. This literally just says, this is the following text is the property of the Wizards of the Coast and is copyright 2000 Wizards of the Coast. Fine. And the open game content means the game mechanic includes any methods, procedures, process, and routines to the extent such as content does not embody the product identity and is an enhancement over the prior art. All of this... Wait, what? Try that again. Let's try that. Try that again. Yes, they literally copy and pasted this. But yeah, so but they're here. The thing is, they're using this as the D20 system. Year Zero engine is a different mechanics system. All of this is basically taking... You don't put in there who the parties are in the definitions. Like, in this one, you know that the... solely through the use of the Open Gaming License version. So, like, the permission to copy, modify, and distribute the files collectively known as the System Reference Guide are if you use this, so you can't reproduce any of their spells or anything unless you use this. The material being released using the Open Gaming License, and you should read and understand the terms of that license before using the material. The text of the Open Gaming License itself is not open game content. Instructions on the using the license are provided within the license itself. Here's the big thing. They don't designate product identity as defined in the section. They give the definition of product identity about what's not going to be covered, and then the Year Zero recreates it verbatim and doesn't give the same definition, right? Like, The product identity means product line names, logos, and identifying marks. Okay, well, you haven't told me what those, including trade dress, artifacts, creatures, characters, stories, storylines, plots, thematic elements, dialogue, language, incidents, language, artwork, symbols, designs, depictions, all of this, you haven't told me what you consider. I legitimately don't know how legal this is. I and a number of people I know could make a legitimate argument that this is not a valid document. Like, the reuse of boilerplate text, generic form, you know, like most people have a form letter. In the legal field, we call that boilerplate, right? It's a form letter, but you have to go then through and take that boilerplate and make it specific to your own field. Because otherwise you're just copy and pasting someone else's contract. And wow, Free League. How can a legal normal figure that out? Whether or not you should recreate somebody else's contract, don't. That is this is my hashtag I'm not yet a lawyer advice. I might not be admitted to the bar yet, but I am an official legal intern and a 3L. Hashtag not yet a lawyer. If you have a contract in front of you and you like the terms and phrasing of that contract, take it to a lawyer and have them recreate the whole thing specific for you. Do your own work on one hand, but on the other hand, boilerplate usage is fine. Like, using a form letter is fine. Just make sure it's like you wrote a form, it's like you wrote a cover letter for your resume and didn't change the name of the business that you're writing every time. Exactly. Flounder says, they are a lawyer. And I will say, don't use someone else's contract. Just don't. It's... Flounder, would you like to vote on an opinion about whether or not the reuse of this entire license is... I don't know that it's valid, right? Because the OGL is literally an open gaming license that was created by Wizards of the Coast to license Wizards of the Coast property. If you are taking their license and using it with your intellectual property, I don't know that you're actually licensed your property in any way, shape, or form. The first step of the action is to find a lawyer. I mean, you can find a lot of them, and a lot of them will do pro bono work. Exactly. Don't say anything until you read the source documents. I'm gonna drop the link in chat just so that you can be intrigued by this, because I don't see anything in this that's literally the way. The open game license is copyright Wizards of the Coast, okay, and its updated version is 2016, not 2000. Introduction. Okay, so licensing. Okay. Yeah, see what you think by the end of the year, no worries. But it's licensing the Year Zero engine. In order to publish a product using the Year Zero and OGL, follow these simple steps. Read the open gaming license found at the base, which is literally the open gaming license from Wizards of the Coast. Copy the OGL license text and include the full text somewhere in your product. But again, that's the OGL for Wizards. Use the text between the dotted lines below as the start of your section 15 of the OGL. Replace all the bracketed text with the specifics of your own product. Okay, so this... like this part right here, year 0, you can't, again, mechanics cannot be copyrighted. Name of this document or material, copyright, that's your copyright. Section with the identification of the following designate the open game contact and product identity. Like, this is basically like if you take out this sentence about free login, right? If you take out the year 0 engine bit, this reads, insert a clear designation of what part of this document you are releasing as open game content, making it eligible for use by others under the open game license. Note that the existing open game content must contain OGC. Example, the contents of this document are declared open game content except for the portions declared. But the person who's creating a product identity, I'm very confused by this. Like, legitimately, I don't know. I don't know if this is valid. Because I don't think... Look, okay. We've been waiting far too long this year for warmth and love to fill the air. Thank goodness that Christmas is... Yeah, I think this is an example of somebody liked what the OGL had for Wizards of the Coast, wanted to use those rules, and didn't necessarily understand you just can't copy their license. It's not a boilerplate, it's specifically their license, and they haven't made any specifications. Like, if we go down here, go down all the way down to their section 15, it's saying all content in this document is considered open content. So yeah, what I'm reading from, what I'm getting from this is somebody took this and basically inserted this sentence. If we delete this sentence, year 0 standard reference document, copyright 2019 for login AB. If we delete this sentence, this looks like somebody was giving someone the directions about how to take the Wizards OGL and as a boilerplate, and they didn't understand what to do to actually make it themselves. Yeah, think we should read that before we copy paste it? No, we're good. Yeah, I mean, like, I also know that Free Login, I don't believe the writers over there, like, Free League, correct me if I'm wrong, but I'm pretty sure that Free League is, the writers and creators are not... They added 14 sections before the copyright notice? Well, to be fair, it's in the same place on the Wizards, but on Wizards they also include the statement of the copy of this license must be included in line 10, and that the license, you know, the description of the license of it, you know, and the original notice of license to copyright is in section 6. But basically, the way I'm looking at this document now, somebody tried to explain to Free Login how to use the OGL to create their own OGL. And instead, they just copy and pasted it, but forgot to put anything that would count as product identity or anything to identify it as their license. Because as it reads right now, I'm really not seeing anything that would delineate as this is their license. Because it even includes, they literally even include the section updating the license. Wizards or its designated agents may publish updated versions of this license. You may use any authorized version of the license to copy, modify, and distribute any open game content originally distributed under any other version of the license. That's referring to Wizards having the right to change their own license for their own product, but if you're publishing something that already had a license, I can't believe they did that. I legitimately can't believe they did that. If somebody knows anybody over at Freelogin and wants them mention, you know, that maybe they should have their lawyers look at this because this is, and have English-speaking American lawyers look at this, because this is, I would not do this. I mean, well, it's saying that Wizards or its designated agents may publish updated versions of this license. And because this license, yeah, exactly. Wizards can now, according to this statement, change Year Zero's SRD. What do you mean? What do you mean, Trig? Do they? Is Freelogin have an OGL section on their SRD and on their And now begins the crusade to update all the game companies' licenses updated. Yeah. I mean, I'm not going to fall into that hole because they're not paying me to. If they wanted to, I am available for hire, and as the legal intern, I can legally do this in the United States and the state of Connecticut. But, you mean Freelogin has one? On their forum. So if I go over here and say, hey, did you, can I be that person and basically say, hey, did you have a lawyer look at this document? 'Cause it's not valid. Perhaps that's the positive outcome of the one D&D stuff. Everyone gets to their licensing stuff checked out. I mean, ideally, if you have a license and you're publishing a license, you should probably check that there are no conflicts of interest in creating a no OGL for Pre-League. This is true. I don't know what my conflicts of interest are. I am currently employed by a particular company that I do not think has any conflicts of interest. I would need a conflicts check on this. Okay, OGL. Right? Yeah, there we go. I think I just found it. Third-party licensee for introduction. Okay, what do they say? Okay, that's just introducing themselves. Fine. I don't want using OGL in product. No, this is about using their OGL, not the actual OGL. Wow, wow. Oh, I would feel real bad just showing up on... Exactly, I would feel, like, really bad showing up on their forum and being like, hey, in a public forum, you might want your lawyer to look at this. I don't mind doing that on stream because we're talking about it and I want you all to be informed. And I don't have permissions to post in this forum anyways. So maybe if I contact them. Yeah, okay. I'm just gonna contact them. Well, no, I'm gonna use my formal... we're gonna write this. We're gonna be very polite about it. OGL. I was reading through your OGL as an exercise, we'll call it that, in legal understanding. I am a current U.S. law 3L law student. I want to be specific. Concentrating on IP law. And I noticed some concerning things about your published OGL. It seems like you merely copied the Wizards OGL, not OLG, kind of like reporting a security bug you don't publish in the world to see as a means to contact them. Yeah, exactly. Yeah, don't post it on the forum, send them an email or call them. Exactly. Like, I'm gonna put it in their contact board administrate, like, no, maybe it doesn't go on the board. No, I don't put this on this one. I don't want to do this. Whoops, I just realized it's the wrong context. I should just put... It shouldn't go to the board administrator. It needs to be not on their forums. It needs to be their actual about contact. Here we go. Don't want to... I'm already on your mailing list. Please don't put me back on your mailing list. There we go. It seems you merely copied the Wizards OGL wholesale and didn't, and therefore, and that might have some concerns, legally speaking. Oh yeah. Yeah, you're correct. Unedited? Oh, the OGL was a stretch goal for their Kickstarter? That explains a lot. Form of record that you sent it? Well, like, my form of record that I sent it is gonna be this VOD. And also, probably, yeah, unedited seems better, you're correct. Unedited. And that might have some concerns, legally speaking, in the United States. Specifically, right? Right? I think that's an important point to point out. I recommend... I don't want to use recommend because I'm not a lawyer giving advice. Crap, I can't use that phrase. You might want to have your lawyers read through this and ensure that it actually protects you as you want. Without tailoring it to your properties. And good suggestion, Commander. Good suggestion. For example, this clause. Where's the text? Oh, did I close the thing? Did I close it? Crap, I did close it. Where did we find it? OGL. Oh, here we go. Thank you, Cached. Nope, that's not what I want. Okay, here, this page. This is what I needed. Oh, thank you. Oh, wait. Sorry. Flounder, sorry. Oh, no, it's fine. Yeah, I just want to go straight down to that section where it literally says they have the right to change. Where did we just... Wizards may publish updated versions of this license. Yeah. This. For example, this clause in section... What section is that? 12? 9. Section 9. Yeah, I'm gonna... Section 9 implies that Wizards has the right to edit pre-league SRD. You might wish to consult with an intellectual property attorney in Sweden, right? Because they're in Sweden. In Sweden, who works with U.S. intellectual property. Wishing you the best and happy holidays? I mean, how do you end this? Thanks, guys, for hanging out on stream while we find that there might be an issue, and we want to, like, I like Free League. I think they're really good people, and while I personally don't want to play Tales from the Loop, Mutant Zero is great. And, Tales from the Abyss is okay, too. Oh, I need to put in, this doesn't count as... What does that mean, Ice Bunny? Because I would copy it, but I don't know what it means in English. And for... This isn't me, this is not official legal advice. I have to put that there because you're not paying me and therefore could be considered away. Do you have a translation for that phrase? Because I will just copy and paste it, but I need to know what I'm copy and pasting. And that is not one of the languages I speak. I like that the clause may imply that Free League may not be able to update their own license. Good Yule okay, so Good Yule means Merry Christmas, and Good Nighter, is that Good Night or Good New Year? Okay. Yeah, it's like, let me... Okay, so if I put it, does it need capitalized or is it not capitalized? Okay. Okay, so if I just... We're just go. Yeah, if we didn't wash our business, if we didn't wish them well, we could just go about our business, and so here we're informing them of goodwill. Exactly. Exactly. We want to be beneficial, and this is a thing. This is where I'm going to give you #NotLegal advice. But if you are anybody who's involved in the legal field, or if you all are not on the other side and you're a writer or a creator or anything like this, and you have questions, hey, send an email to a friend that you know might be a lawyer. Now, they might have to tell you, hey, I can't help you with that because of conflict reasons or other things. But most of them will at least be able to direct you in the right direction to help you get over your issues, right? Like, lawyers are out here. In the United States, we have to do a certain number of pro bono hours a year. It's required. And if you're in the state of New York, you can't even get on the bar without doing 80 hours of pro bono hours. Okay. I'm gonna just update the spelling then, based on the... Oh, there's an R. I almost missed the R. Okay. Could you got nine yard? I guess. Alright. It implies that Wizards has the right to edit Free League's SRD, and you may have looked, and I don't want them to. Alright. You might wish to have. Well, this is not official legal advice. Merely a recommendation from someone with knowledge who wishes you all the best for your game or company. Wishes you all the best for your game, I think, or for your content. Yeah, let's go with that. Period. Yep. For your future endeavors. Yeah, there you go. Oh, all the best? Just leave it there? Alright. Wishes you all the best. And then... There we go. Alright, we have hit send. And now it's thinking. Alright. Wow, and it's thanking me in Swedish. I'm glad you can give me the thanks in Swedish. Alright, now we feel like we've done our good deed for the day. Again, I want to reiterate. If you're publishing something, consult with lawyers, but also recognize that no lawyer knows everything. And lawyers will frequently go and consult with other lawyers. The giant "it depends," while can be annoying getting an answer from people online, is the most accurate answer for most lawyers. Exactly. Positive vibes out into the aether. And it is a thing of... Oh, they said they will get back to you ASAP, likely after the holidays. Okay, good. Enjoy your holidays, Free League. Have fun. Take your holiday. Enjoy whatever holiday you are practicing. Yule, New Year's, Christmas, Kwanzaa, Hanukkah, anything in between. Enjoy your holidays. This is just merely an important point of, like, looking at... And this whole conversation, this whole day of stream, which we started at 11 o'clock, by the way. And if you missed any of the pieces about it, I told people in chat earlier, I will be putting this up on YouTube. If you want to take clips of this, go right ahead. I'll be putting this up on YouTube. This is an information to try and help people. Help game devs and game writers, but also help other people who are reading this stuff and don't understand it. Wow, okay. I know that R. Telsorian does not have an SRD. Does Green Ronin? I don't think Green Ronin has an SRD. I don't think they do because they have a lot of licensed. Okay, so let's look at their age system. Yeah, I don't think... Yeah. Green Ronin doesn't have an SRD. That's not actually a surprise. No, actually, Flounder, there isn't a license for PBTA. That's one of the really fun things. Well, yeah, so Green Ronin doesn't have an SRD. Apocalypse World. Apocalypse World, from our very dear friends, D. Vincent and Meg Baker, who are some wonderful, wonderful people who do a lot of things for the community. They're also really great writers who write really good, great games that I really enjoy. Also, Meg is just a great person and was a wonderful to hang out with at PAX U a couple years ago. So, PBTA is something that is literally isn't really a license, right? Because this is an open letter. They're open. Yeah, Genesis has an SRD. Yeah, but not after Fantasy Flight. Yeah, that makes sense. And Green Ronin doesn't have an SRD for any of their products because a large number of their products are licensed, officially licensed works, like their Dragon Age game, and their like when they have a Song of Ice and Fire. All of those games are licensed games, so they don't have an SRD for is Fate licensed? I don't think so. I think Fate is Common Core. Fate RPG. We'll come back. We'll oh, the Fate SRD. There's an SRD for them. Okay, we'll come back to that. So the open letter about PBTA. So it is a policy, not a license, which is interesting. If we look at this, dear letter, this is directly from Dave Baker, an open letter powered by the apocalypse. Dear friends, fellow designers, critics, and concerned citizens. It was a going topic, not to say a sore point, at Gen Con, so please allow Meg and me to define once and for all what Powered by the Apocalypse is. Powered by the Apocalypse isn't the name of a category of games, a set of game features, or the thrust of any game's design. It is the name of Meg's and my policy concerning others' use of our intellectual property and creative work. This policy appears in all of Meg's or my public statements on the topic, we hope, and we try to include it in our answers to all private inquiries. It's possible that some of you have never happened to encounter it before this, but our hope is that it's more or less common knowledge. It's stickied at the Barforth Apocalypticum forum, for instance. Here's the policy. If you have created a game inspired by a apocalypse world and would like to publish it, please do. If you're using our words, you need our permission per copyright law. If you aren't using our words, you don't need our permission. Although, of course, we'd love to hear from you. Instead, we consider it appropriate and sufficient for you to mention Apocalypse World in your thanks, notes, and credits section. It's completely up to you whether you call your game Powered by the Apocalypse. If you would like to use our PBTA logo in your game's book design or trade dress, ask us and we'll grant permission for you to do so. This isn't a requirement of any sort. This isn't even a Creative Commons. This is a very interesting verbal license that if you use it, unless you're taking directly from them, you don't have to cite them, but they would like you to acknowledge the existence of Apocalypse World, and that makes the most sense to me. This is why Dave and Meg are such good people. Vincent and Meg are Vincent and Meg are good people. Why did I call him Dave? That is wrong. His name is Vincent. So in other words, is Apocalypse World an inspiration for your game? Enough so that you want to call your game PBTA? Did you follow Meg's and my policy right with regards to publishing it? Then cool, your game is powered by the apocalypse. Get with us if you want to use the logo. Exactly, we can't copyright rules, we can't copyright mechanics. Did you copy any of our phrasing and expression? Then please let us, we'd appreciate the shout out. This is actually a very sane, because here's the thing, a powered by the a game based on Apocalypse World, and that is, again, powered by the apocalypse, is trade dress, which I'm actually very impressed that Vincent is using this correctly. Yes, so again, this is what it means to be powered by the apocalypse. This is effectively their SRD. If you want to use the logo, you have to get verbal permission from them. If you want to use their design and trade dress, then and layout, you have to, well, layout maybe not, because layout can be considered scene of fair or in term of art. Exactly. So this is very useful, and this is a good example of someone who is intelligent and understanding and may have actually spoken to his attorney. All right. So what is, okay, so this is the SRD. Okay, so remembering, of course, that the system reference document for an SRD, the SRD is what you are basically the mechanics in an expressed form that are easy to use and copy and paste. Fate accelerated, okay, toolkits for the SRDs, but where's the actual worlds for the of adventure SRDs? All right, so those are official licensing. Let's go with this. Here we go. Okay, official licensing. Licensing of Fate Core and Fate Accelerated is now possible with the July of our system reference document. Licensing options, Creative Commons attribution, okay, which basically means for the second, your licensed system reference documents and all licensed content listed on the top page are available through 2 licensing schemes. Okay. Oh, please don't tell me that they did the same stupid thing. Wow. So, hey guys. Hey. Hey. But Flounder. Exactly. Flounder says, if they did the same stupid thing, would it be an industry standard not to do this properly? This leads to the question of, insert a clear indication of what parts of this document you are releasing as open game content, making it eligible for others to use the open game license. Note that the existing open game content must remain OGC. Contents of the document. Again, it doesn't state, literally doesn't state, what examples you're going to use. Oh my god, or they did this. Is there a lawyer at WotC that's getting that's making shit tons of money off of this? No, that's not actually it, because the rest of the contract doesn't involve Evil Hat at all. WotC probably had Hasbro's lawyer do it? Yes! Yes, they did. Okay, now we need to go look at... Work opportunity tax credit? No, I want Wizards of the Coast. Come here, Wizards. Okay. Okay. Okay, so they have the SRD. This is the SRD. Also, it's also the version of the OGL from 22 years ago. Yes, and the OGL is an updated document and a living updated document. So does that mean that every time they don't recognize the fact that every time WotC updates its... It's a contract that has multiple parties, but the base party of the OGL is Wizards of the Coast. And if you're not... No, you wouldn't... Hawkeye asks, does Wizards of the Coast get royalties for others using their legalese? No, because it's probably become a question of the document itself might be considered boilerplate, which is fine. the general expression of the contract as a boilerplate is fine. It's the fact that it's this statement right here. Open the... We're going to be borrowing the... Oh, here we go. Here we go. Here's where we've got a culprit. Copyrights of the OGL. Oh, here we go. Oh my god. You can fudge rules, you can't fudge copyright. Just... Well, that's not the thing, Pulsar. Pulsar, that's the thing. Inherently, when every time Wizards updates their license, they state that all other forms of the license are now incorporated into this one, and that other document is no longer valid. Yeah, exactly. Fudge dice versus fate dice. Okay. Okay. Okay, so this is the copyright and permissions where they literally just took the OGL and copied and pasted it. And at least they added a designation of product identity. Exactly. All previous versions are null and void. Exactly. So if you are basing your license as the license of a previous form, you need to have a delineation that it's not the same. Like, that's why you can't keep that clause about that it can keep. Exactly. X might not be valid for X years. X being defined as the most mana you open tap. Exactly. See, at least this includes the designation of product identity and what is being designated as open game content. It's not good still, but at least it's, you know, it's getting closer to using the OGL as a boilerplate, but still isn't quite. Yeah, it is better, strictly speaking. Okay, so what are they doing with their... You want to use Fudge logos. That's the trademark license, so they included a trademark license. And they include a terms of use. So Fudge is not horrible. Well, text of this document is open game license found it and is incorporated here by reference. See, this is actually... Okay, this is somebody who is a lawyer and included stuff. Fudge is a role-playing game. You need to include... Like, so they've added the delineation and are basically giving you this to copy and paste. And they're not... no one's actually read or understood the fact that you have a different step where you need to delineate that you're not wizards and you are using their text as boilerplate. But by keeping the fact that, but you're still keeping the, oh my gosh, it's not found. Oh my gosh, because it's not like, it doesn't exist anymore. Do it. Okay, so it gives the appendix, the definitions, the license. Nope. still includes the wizards may or designated agents may update any versions of this license. And no, exactly. Get a lawyer and let them make your you saw online. Now, the general concept of using open gaming license as a boilerplate is fine, but you need to then make it your own. And I don't like Evil Hat well enough to go and write them a whole stock letter like I wrote Free Login. Somebody else wants to go do it, they can. Yeah, exactly. It's a template. Hi, I'd like you to take this and write it for me. But this, Hey, Flounder, I figured out what their problem is. They believe... Here. They believe that the license are the terms of the license and not the document as a whole. Because they're just copying everything after the terms of the Open Gaming License version 1.0a are as follows. Hey, you know these introductory paragraphs which delineate and express that the Open Gaming License itself is not open game content? Hi. This statement right here but exactly the four corners of the document. Oh, Hawkeye, yes, this is, if you had, yes. This is the worst case of telephone ever. This is, somebody liked this thing, and then Free RPG went and was like, oh, well, we can use this. Or Fudge RPG is like, oh, we can use this and fudge it. No, you can't. Another takeaway for everybody. I want you all to see this. See this? Don't fudge the legalities. You can fudge dice, you can fudge rolls, you can fudge rulings in a game. Do not ever fudge the law. It will not end well for you. Jer says where we're going, we don't need corners. No. In law, you need those corners because it is part of what is called intrinsic and extrinsic evidence. It is very important. It is about introducing evidence that might contradict the words on the document. Okay, so a contract isn't... The corners are in your corner. Exactly. Don't just pick and choose what you like out of this. The license, the OGL, the license, what Wizards is offering you as the OGL is this whole 2 pages of document. Parole evidence, thank you. I was getting their words. Oh, you can drop that. Exactly. Round room syndrome is bad for lawyering. Exactly. You can drop that link if you want, Sphinx. The license is these whole 2 pages. Everything else, all 401 pages after it, is the SRD, which are the rules that you are allowed to incorporate. But the OGL itself, the license, is both of these 2 pages and includes more than just the specific terms, it includes all of the introductory paragraphs. I legitimately can understand that there are... And I have legitimate questions about then, did Evil Hat consult with a lawyer, or did they just decide, hey, we can take because the way it reads, right, you know, we're going to borrow Fudge RPG's excellent boilerplate approach here. This isn't right. If you want to use the Powered by Fate logo on your product, you need a main license, which is true. Good. You know that you need more license, but this is... At least we know where it got started. But this is a not clear example of